ये बड़ा नहीं होता। अबे आ जा। ये आवाज है कहाँ से? आवाज कहाँ से आ रही है? आवाज कब दे जरा।
Serial number 35, my lord. I'm for the accuser.
Lord,
Yes, Mr. Solicitor General.
yes,
Yes.
Lord, I'm sorry for the inconvenience being caused. But I'm mentioning the matter which is coming up tomorrow, my lords.
Yes.
Lord, there is some difficulty. There is a personal function, my lord, on Saturday itself.
So where is your opponent or the appellant?
Dr. Singhvi is here.
I appear for the appellant in that case. Court may kindly recollect, after making a mention, the
Yes.
matter was directed to be listed tomorrow.
No, there is some personal ground is urged.
He is only a formal respondent.
We have no difficulty in
Court
taking
may
up the matter on
kindly
any day.
hear me.
We have no.
My
we have-
learned friend is appearing for the governor.
Correct.
No, my lord,
The governor is whatever he wanted to do, he has done it.
So since the
That is under challenge.
my lord, there is
I
some
have no
difficulty.
objection to adjourn it. I have no objection to adjourn it. If there is
Correct.
any problem. But in the interregnum, let there be an interim order.
No. Without hearing, how can you ask the
Hey, Learned Advocate General, I have spoken to Dr. Singhvi about
We are
the
not-
problem.
We are not
I
aware
could
about
not
the
speak to-
real controversy. You will just to argue the matter. Where is the question of granting any
No,
relief?
that is precisely. I'm
So
I'm
we-
impressing upon the urgency of the matter.
We will put up at the date earliest convenient to you and the court, but
Very well. May I request for
may have to be exceeded to because
may I request for 28/11.
Lord, any day
28/11.
after 3rd, my lord, any date Dr. Singhvi can choose, my lord. He is
28 to 3rd convenient.
28 to 3rd.
Well, my learned friend,
Monday.
let us be very
Monday.
clear.
Up to
Well, can
3rd
I-
not convenient.
Can I
If it is
just,
on Monday,
Monday is 2nd.
2nd.
can I just say something?
No,
Well,
the coming Monday. That will be 25th.
Whatever you decide. Let it be on.
Can your
5th.
lordship hear
Dr.
me?
Singhvi,
Can
Dr.
you
Singhvi
hear
is
me?
there.
Yes, Mr. Singhvi.
Well, sir, can I just take 2 minutes? Number one, in a lighter vein, I
Yes.
told my learned friend when he telephoned me that I am asking for a issuance of a IOU by him to me, Malas. I'm accommodating him because I meant, and your
Mr.
lordship
Singhvi,
put this.
your voice is getting interrupted.
Well, I
No,
was
Lord,
joking.
he
I was
wants.
joking with my learned friend that
Yes.
he should issue a very specific IOU to me because I got this date for physical appearance on Saturday and your lordship are kind enough to accommodate me. But nevertheless, Malas, he is making a request, so I can't oppose it. Your lordship may, Malas, then consider a date when possibly Malas will be
Since
virtual.
learned Solicitor
Will be
General is
virtual.
mentioning on the ground of some personal.
Yes, that's
Present
why
and-
I'm accommodating him.
Lord, I have
And
conveyed
I'm
to Dr.
looking-
Singhvi the ground, my lord.
Mutually select the date and we'll proceed with the matter.
Malas, can it be before what date you want, Mr. Mehta? Yes.
No, can it
What
be
date you want?
7th? Well, in the week of 4th. I'm sorry, week of 3rd,
No, then
4th, 5th.
let it be fifth, Malas, fifth.
With what
No,
we
fifth.
what we suggest
Fifth.
subject to your 5th
Five,
or 12th.
Malas.
5th or 12th.
Five, Malas.
5th.
Five.
Mr. Maninder Singh is for the contesting respondent.
Yes,
Yes.
5th is fine, my lord. 5th is fine.
Five.
5th is fine.
5th is fine.
5th, all right. 5th of December. Right. So all matters which are going to be listed tomorrow shall come up on 5th of December.
So only this matter. The
No,
other
Malas, this
do
matter,
not
I'm
know
only
somebody-
appearing in
They're
one,
not,
Malas. I have no connection
the
with the
other
other.
matter is not connected
I
with
have no
this.
connection with the other matter,
We are
Malas.
told that it is rising out of same subject matter.
No, with great respect. What is under challenge is a sanction given by the
Whatever it is, but some matters which were mentioned to be posted on Friday, then the council who mentioned considered that it is related to same subject matter. So we have directed to put all together on Saturday. So all will come on 5th now.
without any
Let it be a global examination.
disrespect.
Why?
I should mention this. They are not
Why?
connected.
Why?
Malas, I
please
want to make one
They-
thing clear. My consent is only for 1569. I only appear in 1569. I am not concerned about the other matter. Your lordship is given fifth for that. The rest is
Lord,
between Malas,
may
those
I,
counts.
Lord, this is Dushyant.
He is
Lord,
not
this
even a
is
public
Dushyant
servant.
Dave.
I don't know how
Can
it
your
is
lordships
connected.
hear me?
My lord, I have conveyed, my lord, the reason behind my.
Lord, no difficulty, Mr. Mehta. No difficulty. It's a good occasion. I agree. Lord, would your lordships only, should be understood by Mr. Mehta and Mr. Maninder Singh that the matter coming before learned single judge on Tuesday will also be adjourned for that reason.
Maybe. Maybe.
So
That is
there
your
I am not
lookout.
appearing, my lord. I am not
No,
appearing.
then you can't have it both ways, Mr. Mehta. Kindly
I am not
consider.
a party, Mr.
So
Dave.
then you are not a party in my matter. Don't mention my matter, please.
I have not mentioned.
Yes, then my matter should go on, my lord. I request that my matter be go, because otherwise they want certain proceedings against me initiated on Tuesday before the learned single judge. So it should be
We-
understood that they will not proceed. Mr. Maninder Singh is appearing in that matter.
If
But
all
I
are
think
eva-
that's a very fair request. Well, both sides should maintain on
If-
that both fronts. Well, that's a fair thing.
if all matters are arising out of same subject matter or some way connected, then we'll like to take it together.
No, the learned single judge's matter is a consequential direction that is sought for a CBI investigation on the foundation of the order passed by the learned single judge, which is
Why
under-
piecemeal? Let us have a global hearing and the global view of the
Yes, my lord, no difficulty. So, my lord, let the Tuesday's matter
No.
be also kept along with
Yeah,
your
Tuesday
lordship's matter.
should not go on. Tuesday matter should not go on.
That's all.
That is your lookouts. We are
No,
the,
the-
we are
the-
a-
an
we are a
No, no,
different-
no. Mr. Maninder Singh is making a request, rightly so. There is a joyous occasion in his family. We respect
Correct.
it. But
So-
he should agree. He should agree simultaneously because he is appearing in Tuesday matter before learned single judge. So he should kindly agree to it. That's my
Mr.
request.
Mr. Dave, all of you are good friends.
No.
Everybody will exceed somebody's.
Yes, my lord, that's true. But sometimes, my lord, we have to make a request and seek your lordship's intervention. Your
So you
lordship
request- You
Yes.
request Maninder Singh, he will agree.
very well. I'll do so. Very well. Grateful, Lord. Grateful.
Obliged to your lordship. Lord,
Obliged.
sorry for the inconvenience
So
caused.
this
my
is on 5/12,
So all will be coming up on 5th of December.
5th.
Finally.
Obliged.
Finally.
Both,
Yes,
both. There are two appeals, my lord. Both appeals would come.
Both, yes, yes.
Yes.
My lord.
One submission, my lord.
Lordship, serial,
Matter may be kindly may be taken up on Monday or some urgency is there in
What is
commercial
that?
appeal.
What is emergency?
My lords, already they have filed an execution petition before the execution court. They are precipitating the orders. That's the reason, my lords.
Monday is not possible. It will go to now in the week of.
Date may be fixed, my lord, at least.
Date will fixed 18th November, 18th December.
Milord, serial number 35, Milord.
18th is too long date, my lords. Because now they are pressing the matter. That's the reason, my lord. Actually, the matter are
Then remove the office objection and wait. It will be listed earlier than the date we give.
Milord, serial number
before
35.
yesterday itself we have
You
filed.
are
There is
seeking
some-
date by filing memo, it will be the date of the court's choice. If you wait by after filing memo, filing the appeal and matter and the wait for listing may be listed earlier.
At least,
But normally get matters are,
end of this month, my lords, at least. I'll complete all the objection before end of this.
then wait, it will be within a week, it will list.
Milord, serial number,
Matters are listed within a week,
Yes.
5 days I am told, yes.
Lords, in serial number 36, the council seeks for a short adjournment because this senior is unwell.
30,
36, my lords.
we will go in January now. 14th January, 15th
Milord,
January.
Much
serial
obliged,
serial
my
number
lordship.
35, Milord.
15th January. Serial number?
Milord, serial number 35, Milord.
Serial number 56, my lord, short accommodation. Senior not-
56. It will go in January, 56. Read petition, January, 8th of January.
My lordship.
Milord, serial number 35, Milord.
Yes, madam.
Serial number 99, my lordship.
99.
matters, my lordship.
Pardon?
Identical matters.
Every day you bring identical.
My lord. It is a partnership firm, my lord. It is not a company. Small scale industry.
95.
Thank you.
15B. $99 disposal.
Milord, serial number 35, Milord. Serial number 35, Milord.
Yes, madam. We will not breach the line.
Memo for posting.
This is the petitioner counsel in serial number 25.
25, my lords. My lords, senior counsel, Mr. Raghavan has been engaged in this matter. Kindly have this matter on 3rd of December, my lords.
Yes, the respondent in.
Filed a memo as
Number
25, my lords.
25.
No,
So-
no, appear for the appellant in serial number 26. And
Oh.
the same appellant in 26 is the respondent in 25. On the last occasion, my lords had adjourned the matter because the TCR, the trial court records had not come. The TCR has come. The only urgency from my end is, my lord, I'm suffering a blanket order. I'm requesting a short date, my lords, any date. next
It may be had on the 3rd of December, my lords.
Third.
3rd of December.
I am for the contesting respondent in both appeals.
The matters may be connected, my lords. And the matters may be connected, my lords, 25 and 26.
12th.
Please shorter date, my lord.
12th.
Obliged.
Yes.
Your Lordship, I'm appearing in serial number 21 and serial number 101. Both matters are connected, Your Lordship. The mediation has failed. I am for respondent number 2.
Mediation has failed.
Yeah, I'm appearing for respondent number 2. We are requesting for a short accommodation, Your
It will
Lordship.
go in January,
January, please, my lord, because it's a family dispute, my lord. We'll try to reconcile the dispute.
7th January. Yes.
Lordship, memo for posting.
Then serial number 101, my lord, which was mentioned.
Serial number
Entry order.
35, my lord.
35. Yes.
Yes, a filing of reply. So any on the adjournment, any adjournment, man.
9th January.
Lordship, serial number 42, Lordship. My seniors had a medical emergency, ma'am. Is the treatment? Kindly adjourn the matter.
42.
Yes, madam.
10th January.
Lord, in serial number 101, there is an entry model. Maybe.
The model will be extended wherever it is.
Memo for posting, my lord. The matter is sent to the office objections. They have complied the office objections. Kindly take it on Monday, my lord.
Wait. It will be posted once you remove the office.
We have complied the office objections. Kindly the matter will be taken. They are connected matters, madam. 2 matters.
Serial number 28 and 29, my lord. Arguing counsel is met with the accent, my lord. Admitted in the hospital. Take short adjournment. Serial number 28 and 29.
28 and
29, my lord. Arguing counsel has met with an accident and is admitted in the hospital.
28 and 29, you want time?
Yes, ma'am.
Time. Because it will go to 16th January.
Serial number 43, my lord. 43.
Still
File
number?
the reply 2 weeks time maybe.
Still number?
43.
43.
43.
Little louder. 43, yes.
To file the reply 2 weeks time. To file the reply 2 weeks time maybe.
10th January. Other side is informed?
Yes, my lord.
Yes, madam.
Serial number
Serial
35,
35,
Your
man.
Lordship.
35.
35.
They have
Any
to file
adjournment?
objections.
I filed to objection, man. Anyone
It
adjournment.
is already adjourned. 35, you mentioned 9th of January.
Much.
Memo for posting, my lord. We have complied the office objections, my lord.
What is the urgency?
Admission at least. Admission at least on Monday.
What is this?
Date will be given.
What is the urgency in subject matter?
They have removed the respondent, the complainant in this matter, my lord. They have removed from, we have got
Removed from service,
house,
house,
apartment.
13th December.
Serial number 57, my lord, sir, request. It's a contesting matter, my lord, I for the complainant. He is
57.
aged about 82 years, my lord, sir. The
Serial
matter has
number?
been filed.
Serial number
Serial number 57, my lord.
57. So what do you want?
Next week, any date, my lord, sir.
Next week, not possible. 7th January.
That's 57 minutes next week because he is aged about 82 years. Sir. The matter has been heard. The
Because
other
why,
side says that compliance has been done, but the fact remains that the compliance has not been done and the predecessor has warned the other side saying that there was a
why not today?
230 minutes. 230.
No 2:30. Today it is listed. 50.
It's listed, my lord, sir. Won't reach, my lord, but still.
Who says it
230
will not reach? How can you say that at 11 that matter Will not reach. It's wrong assessment.
I'll wait for
Can't
him.
say at 11 that matter will not reach. Yes.
I'll wait. Please.
Now that,
Still number, contempt matter, still number 1.
no, sir, dictation.
So, still number 5.
So this is writ appeal number 1533 of 2024. Or learned. It is serial number 4. 5. Vaishali Hegde for the appellant. Learned, you are appearing, who appeared?
For respondent number 2, my lord.
And you are for?
Respondent number 1, University Lease.
Learned is Farah Fatma
Please.
for respondent 1. And learned minister? Adit Chandra Gowda for respondent 2. The present appeal arises out of common judgment and order of judgment and order dated 19th September 2024, passed by a single judge in group of petitions. Also, the present appeal relates to writ petition number 9975 of 2024. The prayer made in the writ petition, in the prayer in the said writ petition, was for awarding 2 grace marks to the petitioner in the subject of psychology by considering her representations dated 5/3/24 and 29/3/2024. Petition came to be disposed of as not entertained. As far as the petitioner appellant is concerned, petitioner appellant is concerned, she has also prayed for additional direction to allow her to attend the second year MBBS course. As the petitions were dismissed, the interim leave granted during the pendency of the petition was observed to be not surviving for consideration. Learn a single judge stated that, an inverted comma, the said prayer does not survive for consideration, as the relief in itself was in the nature of interim relief, pending a year, 86 page, pending adjudication on various issues, including that of award of grace marks. It was pointed out that during the pendency of the writ petition, interim orders were passed and such interim orders operated in favor of the petitions. 15/4. In the order dated 15/4/24. Court directed, Attorney Single is directed, petitioner shall be permitted to attend the classes of second year MBBS, subject to the result of the petition. Again on 24/4/24, it was observed that the first year students are permitted to attend the second year classes, which will however not vest any right in the student who may attend the classes. Thereafter on 18/7/24, by reserving the petitions for orders, it was observed and directed by the single judge that the petitioners stick to oil examination beginning from 9/8/24. It was provided that the petitioners were free to do so as regard the subject matter of the present petition without prejudice their rights in the present petition. Subject of course to on 18/7/24 again, while reserving the order, it was observed and provided by the court and put this red, green line. Continuity, but inverted commas. In course of the consideration of the appeal today, it was undisputedly stated by learned advocate with the petition that the petitioner attended the second MBBS classes in terms of the interim order and passed out. You passed out.
Past document, page 267.
You passed second MBBS.
Past first year.
And passed the first MBBS. The petitioner has already passed the first MBBS. A request came forth from the petitioner that since the petitioner has passed second MBBS and has also attended the classes for passed this first MBBS and has also attended the classes of second
MBBS and taken 3 internal exams of the second MBBS.
As well as taken 3 internal examinations for the secondary MBBS. She may be permitted to continue with the studies in the second year. Full stop. In response to the above submission, it was pointed out by learned senior advocate, assisted by learned senior advocate, appearing for the university, that where is that statement? Where is your statement about attendance? Attendance.
She is required to have 75% and 80% attendance in the second year. It's 18.
Kelly. From the statement of objections filed on 20th/11/24, that the appellant student has been falling short of attendance. The attendance details furnished by the university in the affidavit is extracted here in below, which is in tabular form. So this page 24. This read. The above details relates to the period from 10/4/24 to 20th/9/2024. What is the significance of 10/4/24 interim order?
Please, Your Lordship.
The date of the interim order was passed on 10/4/24 when the student was permitted to attend the class, when the appellant was permitted to attend the classes. Although it was a submission made on behalf of the petitioner that the attendance was required to be counted from December 2023, such submission could not be countenanced by the court since the interim order was passed on 10/4/24 only, and the attendance to be validly counted has to be from that date. Paragraph. The minimum attendance required is
75% and
75%
in the second year.
each of the subject.
From the date of the order of the learned single judge, she is required to attend
So,
classes for the
this,
second year. And obtain 75% and 80% attendance.
This 75% minimum percentage will have to be reckoned from 10/4/24. So the above tabular form shows that in none of the subject, the petitioner has been able to reach the benchmark of 75%.
Your
The
Lordship.
court is of the view, paragraph, that even though the main petition is not entertained and stands dismissed, there was an interim order passed by learned single judge as above, permitting the appellant petitioner to attend the classes. The said interim orders are worked out for itself, as during the pendency of the petition, the candidate, the appellant attended the classes, full stop. The attendance secured by the appellant accordingly has to go to the benefit to the appellant student. At the same time, for claiming any further eligibility to appear in the second year MBBS examination or taking any such internal examination for the second year or any for prosecuting further studies, the petitioner, the appellant should satisfy the minimum, will have to satisfy the minimum 70% attendance in each subject, which may be counted after giving adjustment to the, after giving credit to the attendance recorded as above upon the petitioner, upon the appellant student attending the classes in light of the interim order of court. Therefore, while disposing of the, without going into any aspect of the merit of the decision of learned single judge, qua the petitioner, since the situation is obtained as above, this appeal is disposed of by providing that the appellant student shall be permitted to prosecute the second MBBS studies and shall be permitted to take examination as and when he completes. He secures 75% of the minimum attendance in each subject, for which the aforesaid attendance secured in view of the interim order of the court shall be given credit. That's all.
That's me, I just see Lord's indulgence, since it would be contrary to the prescribed regulations, Lords may consider saying this order is being made in the peculiar facts and circumstances.
This order is
Because
passed
it should not become a precedent for others.
in wake of the situation obtained that the petitioner enjoyed the interim relief and thereunder attended the classes.
In the peculiar circumstance, this order is being made.
Which is the circumstances peculiar in its.
Of
Which
interim
is the
order by the
circumstance
learned singers
specificate.
despite not being entitled.
Supreme Court says don't use this.
No, I understand. No, I don't want to come in the way of the Lordship's giving her the benefit of attendance. I'm only saying, Lord, this should not become a precedent for others to go before the single judge to claim that there should be an interim order, which is prohibited by law.
It is agreed by parties that the present order is passed in the peculiar facts and circumstances.
Grateful to your lordships.
Write down. In the peculiar facts and circumstances, more particularly when during the pendency of the interim of petition, she attended the supplementary examination and also passed the said examination. So it becomes a peculiar. Peculiar as well as.
Yes. That's her appearance in the examination was after the disposal of the writ petition by the single.
We are aware, but then we'll not permit the.
It's all right. I factually, I did not want that to happen. Lordship.
Contempt matters, still number 1, Girish MK.
My lords, this complainant was a tenant with the tenant under the respondent, my lords. The respondent initiated a ejectment proceedings against the complainant and filed a suit, small cause suit before the court of small causes, and that she obtained a ejectment order. I preferred a CRP before this honorable court, my lord. Annexure page. Annexure C, my lord. This honorable court granted me 1 year time, as 1 year time to vacate the premises, that is up to April 2025. In the meanwhile, my lord, during the subsistence of the order of this honorable court and during my stay, they have demolished the old structure and in contempt with, in opposition to the order of this honorable court, my lord. Page 27, my lord, having regard. At this stage, the learned counsel for the petitioner submits that petitioner has been running a dental clinic since 2015 and reasonable time may be granted to vacate and deliver the vacant premises. Having regard to the fact that the petitioner is running a dental clinic, in my view, it would be appropriate to grant 12 months time from today. So up to 23/4/2025, 12 months time granted. My lord, annexure page 13, my lord, that is the English translation. On 18/8/2024, they have demolished the structure, my lord. I lodged a complaint also, my lord. So thereby they have virtually thrown me out of the premises, even though there is an order of this honorable court for my continuation, my lord. Thereby they have committed contempt of the order of this honorable court, my lord. Photographs I have produced, my lord.
Notice 8th of January.
This is number 2, Padmanabha.
Complaint. Page number 28, my lord, para 12. The respondents are directed to consider the case of petitioners 2, 3, and 5.
Notice,
approval
9th
of
January,
the
9th
amendment
January.
made to the standard staffing pattern with effect from 16.
Bill number 3.
Notice.
Azhar Ali.
The matter pertaining to custody of children. There were 3 orders passed by courts directing the accused to afford weekend custody to the petitioner. That order of 12th July 2024 has been violated from that date onwards. A second order on 1st October was passed, directing her to give access during the Dasara vacation. That was violated as well. And a third order of the family court that the child be sent to the father's house during the Diwali vacation. That also was violated with impunity. So this is a respondent who has scant respect to the orders of this honorable court. My lord will see the first order of 12th July, the operative portion is at page number 33. From 12th July, we have not had access to the children, violated with impunity. The second order
So you are agreed by this page 47 order? Which order you agreed by?
I'm reading the order of 12th July at page 33, my lord.
Page 33.
33, ink page 33, the operative portion of the order number 1. The grandparents and the father can exercise the visitation right at their place. On every Saturday, the father can pick up the boy from the mother's place by 10 a.m. and the boy can stay overnight, and on Sunday by 10 a.m. the father shall drop the boy at the mother's place. Violated with impunity from 12th July onwards. A second order passed on 1st October 2024. My lord will find that order on page 36.
So then there is subsequent order passed by the family court at page.
That is for Diwali. That is only for Diwali. That is only for Diwali.
So what happened to that?
That also was violated with impunity. Dasara vacation, we had no access. 3 orders violated with impunity. Yes.
Please you notice. When do you want return never?
At least the December vacation, we like to have access before. First week of December can be listed.
First week will not.
Second week, my lord.
12th December.
I'm very grateful.
Number 4. Terangana test Joyce. Number 4.
My lord, appear for complainant, my lord.
Third learned advocate.
Order. Order of this honorable court, my lord. Annexure C, page number 24, my lord.
Page number?
Operative portion of the order, my lord.
Page number 24.
24, my lord. Your lordship order. Next, my lord, page no operative portion of the order.
Third
Tab
learned
number.
advocate who appeared to video conferencing. Notice written on 9th January.
Much of.
Five disposed. Seal number 6, Mr. Sanjeev BL.
Correspondent number 1 in this case.
Okay. Monday.
Monday.
Published.
Stays to be continued. Interim order is to be complete. End order shall stand extended till.
This number 7, Shirish Krishna.
Matter was considered for some time, my lords, on the other day,
Isn't
about
that-
absorption and
Repatriation and
Okay.
absorption.
Limited.
There is the limitation issue also, my lord, and we had also issued the GC order. It was, it was heard at length, and I had also submitted my,
Reserved for order.
published.
please.
Third learned advocate, Mr. Learned senior advocate, Mr. Swans, assisted by learned advocate. For the petitioner and learned additional government. Advocate, Ms. Shweta Krishnappa, for respondent state. Full stop, reserved for orders.
Much obliged.
Seal number 8. It's a PL matter. Mr. Murali Krishna Brahmanandam, party in person.
Did not comment.
Mr. Murali Krishna Brahmanandam, party in person. Seal number 8.
This petition has been posted on board from time to time. From awaiting the presence of learned petitioner party in person. As the petitioner appears in capacity of party in person. Paragraph 1, 22, 24. The court had passed the following order. There also the petition came on board, but learned person was not present. Except today. But in person is not present. The order sheet shows that remaining absent of attendance out of party, learned party in person. Even as back as on 1/4/2022. Then the petition was posted, he was not present and the petition was adjourned. Full stop. The petition is 2 years old, okay, but has not been proceeded with any of the above circumstances of terms of learned part interest. There's a last opportunity to be listed on 16th of December.
Seal number 9.
Let's appear for BBMP. I'm filing my compliance affidavit. I've also made a compilation of all the
These roads. So anything remains?
Well, this is an ongoing issue. And they have, the lordships are also very well aware what is the state of the roads in this. Now, this is a report, my lord, it doesn't really reflect it's totally contrary to what is there. But just a few photographs of some.
No. Those
What
photographs
would
are only a
have been shown?
compilation. The compliance affidavit is filed in the affidavit, my lords. On the questions that was put by the court itself.
We'll have a look at this and then we'll give our response.
Yes, matter. Yes, matter. Yes, matter on the. Why should we?
We'll hear on someday.
Yes, but we'll just have a look at this just now he's given. We'll have a look at it and we'll file one response. And then also give a comprehensive way on which we could further.
How to deal with the
kind of
problem.
close this petition.
Grateful.
So tell your date and we'll.
My lord, sometime in January, my lord, your lordship would consider.
13th. 16th January.
Please.
Learned Prashant.
Yes, my lords.
The Bangalore Nagarpalika files further response. Files further complaint, further affidavit, which is taken on record. Full stop. In view of filing of the affidavit, learned advocate Ms. So and so for the witness. For time to go through the affidavit and appropriately respond to the full stop. Stand over to 16th January.
Okay.
Seal number 10.
10 will resolve.
This is regarding demolition of a temple, what they have sought for, my lords. Supreme.
So it is over.
No, my lords, we'll consider the representation in accordance with the direction of the Supreme Court. My lords. So there cannot be a mandamus to demolish. We'll consider the representation, keeping in mind the observation made by the Supreme Court.
Submission.
Yep.
Show that, I'll show you. It is not applicable to the present temple.
We'll pass the order. Appropriate order. Third.
Please. Can
No,
I give-
I want to
Can I
submit
give?
law
if
data
your lordship-
sharing.
No, it's a written
There are
submission.
similar matters, my lords. Can I give the list to the court officer, my lords, where
How can be similar?
the similar is there where the PIL has been filed to demolish religious structure which are on the public road. The question of fact, the distinction between pre-2009 and post-2009, my lords. I'll give a short note also.
This is, we can't generalize it. You may.
If your lordship, that is my case, my lordship, that you can't, I'll point out that to your lordship, that's all. You cannot generalize it. What the Supreme Court direction is, what the complaint.
Sir, we pronounce this order, then we may get it.
Please, I bow down to your lordship. I'm on the same page.
Next step.
Number 11.
Here for the petition.
Srimati.
Here for the petitioner, Your Lordship. This is the case on advanced medical directive. The case on advanced medical directive, where the government was supposed to appoint a custodian to collect the advanced medical directive.
My lord, we have initiated that process, my lord.
Rising out of the common cause judgment passed by the Honorable Supreme Court, if Your Lordship were to see page 250. 250. Para 250. Part of the modified judgment. Para 189.3.6. Wherein it says a copy shall be handed over to the competent officer of the local government or the municipal corporation or municipality or panchayat, as the case may be. The aforesaid authority shall nominate a competent official in that regard who shall be the custodian of the said document. Now, a lot of senior citizens have prepared and executed an advanced medical directive, but there is nobody appointed by the state.
My lord, we have initiated the process, my lord, and we have also placed before the government, my lord, as to who should be nominated as the competent official. If my lord could grant me some time, my lord, then I'll get back to my lord to inform my lord as to what stage, my lord, that appointment is in.
If I may be permitted to make one submission, Your Lordship. The only urgency in this matter is that they're all senior citizens and the point of making this advanced medical directive is that tomorrow if a terminal illness happens, then the process is ready for them. Otherwise, having executed an advanced medical directive itself becomes diluted.
We'll keep this on third. Then we'll grant you the time on that further time.
Obligement.
Great.
Because at least I have not gone through the.
No, my lord, I'll see that the official is appointed by that time, my lord. I'll make an effort.
3rd of December.
Great.
Reading. Till number 12, Chandan K.
May I be pleased, my lords? I may be permitted to represent on behalf of counsel for the petitioner in this matter. I may be permitted to represent on behalf of counsel for the petitioner in this matter, my lords. My lords, the matter is with respect to challenging the action of the respondent authorities in not adhering to the notification of the tender dated 18/12/2023, my lords. My lords, so please, before I make my submissions, I would like to pass on a brief summary of the tender notification is concerned, my lords. That's in fact, there was a lot of fraud committed in this matter, my lords. The 4th respondent have filed a tender bid by stating that he has an experience and he has produced some work orders are concerned. However, with respect to the similar tender given in the year 2022 by the Visakhapatnam Naval Department, he himself have agreed that he doesn't have any experience sort. I request my lords may kindly see page number 29, my lords. Page number 29 is tender notification, my lords. It was dated 18/12/2023. But subsequently, there were certain conditions were given and also the terms with respect to the pre-bid meeting were also laid down. Now I request my lords may kindly turn page number 32, my lords. Point number 2. It specifically states about the minimum qualification requirements. Where, my lords, under subclause B, technical capacities, the firm should have, I may be permitted to read, my lords.
Who are you?
Well, it's petitioner is a company which provide men to the ships and submarines as a crew members for the cleaning and for the set purposes when the submarine is sailing for the naval command. Now the tender was issued.
Engaged in some business.
My lords?
You're engaged in what?
My lords, I'm not engaging any business, my lord.
Oh.
What the present petitioner does that when the submarines and the ships were sailing in the sea, the petitioner provide a men for the purpose of cleaning and for all the purposes in the submarine is concerned.
So
now the tender
you are engaged in the business of providing what? Personnel.
provide men for this, as a crew members of the submarine and the ship.
Manpower
Manpower.
to clean the ship,
Indeed. Ships and submarines.
ship and submarines.
Indeed. There was no self-interest in the PIL, my lords.
And what is this?
Only the public interest at large. The perspective is,
We understand.
my lords,
And this tender is in respect of what?
tender is perspective to undertaking of testing of an acoustic emission testing, which involves the HP cylinders in repairing them and in rectifying them, which are on board ships or the submarines. It involves a high danger critical equipments, my lords, as there exist cylinders of a HP air bottles. If there is any minor mistake done by the unofficial respondent, it would lead to a grave injury. The whole life of the crew members are at stake. My lords, the question is this, my lords. The similar tender was called for by the Visakhapatnam Naval Department. They themselves, the fourth respondent has submitted an undertaking that he doesn't have any experience with respect to the acoustic emission testing. When it comes to the matter of a Karnataka Western Naval Command, he simply submitted the work orders. Kindly see page number 32 for a movement, my lords. It was a prior requirement that needs to be laid down. One must have a prior experience in doing the said act.
Yes, you are going to file some reply. Please, Miller.
Let's request, my lords, may kindly see page number 85 for a movement, my lords. That was the crux of the present PIL, my lord. Page number 85, my lords. That was the crux of the present PIL, upon which I'm relying upon. My lords, this was also the same contract, the same tender issued by the Visakhapatnam Naval Command, wherein which the fourth unofficial respondent have made a representation to the Admiral Superintendent on 4th October 2022. Second paragraph, background. I may be permitted to read on, my lords. Experience in doing AET on HP air pipes and bottles on in / marine / offshore vessels by participating company for or the MOU partner has been one of the qualifying criteria for the above RFP. We have participated in the tender with the MOU. So and so, Mumbai having extensive experience of AET. However, in oil, gas, petrochemical industry, as we have only purchased the equipment and no orders were executed. Well, this was on 4th October 2022. Now I request my lords may kindly see page number 101 for a moment. That was the work order. That was a work completion certificate issued by the fifth respondent. This was on 27 September 2022. Means prior to the undertaking that was given by the unofficial respondent to the Naval Admiral Superintendent. In Visakhapatnam, they say they don't have any experience. In Karnataka, they produce a work orders.
So number 4 is not eligible.
My lords, he is not eligible, my lords. He is an inexperienced.
So what do you say?
Please, my lord. My first submission is this, my lord. In these tender matters, my lord, PIL is not maintainable. My first submission is that, my lord. Sir. May I read para number 5, my lord, from 4?
That's, I may be permitted to submit on this judgment.
The
my lords.
second part is this, my lord. The second part is,
This doesn't say that in tender matter is not maintainable. Where is that page?
Because in fact,
Lord,
this,
it's here, my lord. Para 4, my lord. My lord, in this case also a tender was questioned in PIL, my lord. Your lordship may kindly turn to my lord, this petitioner is social worker.
Lords, I may be rectified, my lords. I'm not challenging the tender, my lords. I'm challenging the authorities in not adhering to the tender conditions.
Para 3, my lord. It has been
For-
stated by the learned counsel for the petitioner, the instant petition, public interest is being filed by the petitioner for the reason on account of the impugned tender condition. Some of the contractors are not able to participate in the tender process.
Where is that?
My lord, para 3, my lord. Page 2, para 3, my lord.
Are you challenging the condition of tender?
No, my lords. I'm not challenging it.
What you are challenging?
My lords, I'm only challenging the action of the respondent authorities in not adhering to the terms and conditions. The terms and conditions of the tender states, which the person who is qualifying to be a bid should be an experienced candidate and should have executed a work prior. That was there in the page number 32, my lords. For a moment, my lords, page number 32. My lords, it is true. PAL cannot be maintainable in the cases of a tender notification is concerned because that is an administrative work of concern. That in the case where I'm challenging the terms of the tender, but I'm not challenging the terms of the tender. I'm asking the respondents to comply the tender conditions. Let's page number 32, point number 2, minimum qualification requirements, subclause B, technical capacity. That is the only thing that I'm seeking from this PIL. Lordship's cotton mallets, I may be permitted to read the point. Mallets, I may be permitted to pass on the judgment of the Supreme Court, where it was categorically stated
Place it on record. We'll place it on record. What is the public interest?
Well, the interest is this. When the naval command issue is a national security is concerned. Once the submarine which was repaired by the unofficial respondent was going into the sea, along with the crew members, and if there is any minor mistake was made, it amounts to a life injury, my lords. So it's a matter of national security.
My lord, my instructions for the time being is this, my lord. The fourth respondent has been technically qualified based on the provisions contained in the qualification criteria. My lord, I will, for the time being, my lord, as this matter had been dismissed for default and coming for the first time now, my lord, therefore I'll place on record, my lord, everything that I will place it on record, my lord. How the fourth respondent is they technically qualified.
My lords, I just would like to make only 3 submissions in this perspective, my lords. One is with respect to the maintainability of the PIL is concerned. My lords, in the year 1981, the Honorable Supreme Court of India may be permitted to pass on the judgment, my lords. Let's paragraph number 48. Where the Honorable Supreme Court of India has categorically established that a person who came with the public interest at large, the doors of the person in that interest cannot be closed. Paragraph number 48, my lords, I may be permitted to read. Lordships got it, my lords. It was a wording given by the Honorable Sri Justice Krishna Iyer Garu, my lords. It was stated, if a citizen is no more than a wayfarer or officious intervener without any interest or concern beyond what belongs to any one of the 660 million people of this country, the door of the court will not be ajar for him. But if he belongs to an organization which has a special interest in the subject matter, if he has some concern deeper than that of a busybody, he cannot be told off at the gates, although whether the issue raised by him is justiciable may still remain to be considered. I therefore take the view that the present petition would clearly have permissible under the Article 226. My lords, it is true. The Tata Cellular case held by the Honorable Supreme Court of India has stated that the courts cannot interfere with respect to the administrative works of therein concern. But the same Tata Cellular case had also stated certain 3 prerequisite conditions that when there exists an irrationality in such circumstances where there is an illegal and arbitrary in allowing the tender is concerned, then absolutely this court has full power to interfere, my lords. Lords, it is a clear-cut case of a fraud, my lords. The submission of the work orders are concerned. On 29 September 2022, he states that he doesn't have any experience. All of a sudden, on 4th October, he gets the work certificate from the 5th respondent. The petitioner also made a representation to the 5th respondent with respect to the genuineness of the work orders are concerned. But till today, there was no response, my lords. And the department simply technically qualified it. Where the Visakhapatnam Naval Command has disqualified him.
Let him not make all such allegations, my lord. I'll come back on that. Without knowing the facts, let my learned friend not make all that things.
My lords, all facts are on the record, my lords.
Let me come
all
back
the
on that.
certificates that were submitted by the unofficial respondent are before, my lords, today. All the certificates that were submitted by the unofficial respondent are before, my lords, today. Page number 101, my lords. Work order issued on 4th October 2022. Visakhapatnam tender is on 29 September 2022. That's the submission, my lords. I may be permitted to pass on the summary that I have made with respect to this case is concerned. Wherein, my lords,
You have not disclosed in your petition about what is your activity.
Let's in fact have disclosed it. That's page number 6, point number 8. In the memorandum itself, I have stated that the petitioner is a sole proprietorship company having its registered office in so and so. The same is represented by so and so. And it was also having a GST certificate. I have also produced a certificate of the company and authorized signatory and
No, where is that? Page
well, let's
six. You're
page number
you're on
24,
page 6 or 7?
paragraph number, page 6, my lords.
Page 6.
Starting page of the memorandum of the writ petition.
So benefit of the general public in name and style of Hindustan technology. The petition has no personal interest. But what is the activity you are engaged in?
Well, let's in fact, the activity is concerned, my lords, have not stated so,
You
but I have
tell-
produced,
Give 2 paragraphs about your activity.
my lords,
You add to the pleadings.
I'll do it.
So learned advocate for the petitioner, Mr. So and so, seeks time to add to the pleadings, specifying the activity and specifying the kind and nature of business and the activity in which the petitioner is engaged. Full stop. Once the amendment is filed, the petition shall be listed. You also consider if you want to.
Please, my lords, on humble submission, my lords. Without issuing the work orders, the work is going to be completed. I request, my lords, may kindly give a direction with respect to not to issue the
First
work
you
orders.
file what are you doing, then we'll proceed further.
But if they issue the work orders are concerned, then the whole.
When it is filed, the petition is filed after how many months?
But it was filed in the month of May, my lords, because after that only we have completed. In fact, my lords, though the
It was
tender
dismissed.
notification,
You did not pursue, it was dismissed for want of prosecution at one stage.
my lords, that was happened only for 2 reasons, my lords. The one is with respect to the public documents are concerned. Those are the tender documents, my lords.
So are you going to file what we want or not?
My lords, I will be doing it, my lords. I'll be doing it, my lords.
Do
My
it.
lords, in fact, I have made a submission, my lords, with respect to the legible copies are concerned. In the office objections.
Why you are feeling hesitant in putting that fact on it?
That's in fact, they are legible is, they are already legible, my lords. That is the only submission is.
What is your activity and business?
My lords, I have stated all of my particulars, my lords. I have filed.
What is that shows?
My lords, particulars are at,
A lawyer who refuses to accept the query of the court is not a good lawyer. We want this averment in your petition.
indeed, my
If
lords.
you want to incline to do that, do it. Otherwise, we're going to pass the order right now.
I'll do it.
We are not hesitant in passing the order.
I'll
Please
do it.
don't take that way.
No, my lords, I'm just requesting, my lords, it's because of.
He has taken in so many terms, so many clear terms,
Indeed, my lords.
in indirect way. But you are not willing to for some good reason. Best known to you.
Let's seek for a sincere apology.
So are you going to file affidavit?
I'll file it. I'll file it.
Additional amendment
I'll file it.
specifying your business and activity kind and nature
I'll file it.
in which you are engaged.
Indeed, I'll file it, my lords.
It is very essential in our view.
Indeed, my lords, I'll file it.
When you are going to file? Learned advocate Mr. So and so seeks time to file additional amendment specifying the kind nature of the activity and business in which the petitioner company is engaged.
Let's next week would be fun.
Whenever, seek the time. As requested, which date?
Let's. Hello?
Which date?
I didn't understand.
Pardon, which date do you want?
Any date, my lords, next week.
You are to file the amendment.
Let's, I'll file it on Monday itself, my lords. So lots
tell-
of pleases on Wednesday.
Wednesday. Very well, Wednesday.
Quickly apply. Let's, in the meantime, there might be a direction that.
Pardon?
In the meantime, there may be a direction that not to issue.
No
court order.
meantime.
My lords, I'm not
Good.
seeking for a stay, my lords, as there is a lacuna on my part. I'm only seeking a direction, my lords.
We are not passing any direction, Mr. Counsel.
They do so. The whole.
Word learned advocate, Mr. Are you going to file?
Lords, I'll file it. I'll file it.
What is this, Mr.? Taking affront to the court. We want this averment. If you want to file, file it. Otherwise, you're going to dismiss it.
I'll do
On
it.
that ground only that you are not accepting the suggestion of the court.
I'll do it, my lords. I'll do it.
We don't understand the approach of the lawyer, that to a very young lawyer.
I apologize.
Yes. Great. And there is a reason why we want, not for the sake of asking you to file the amendment. There is a reason why we want that.
Now I understand.
And that you understand very well,
Now I understand.
more than us. Yes. More than us, you understand.
Lords, I seek pardon for that. I seek pardon of this bench for that, my lords.
Pardon?
I seek pardon of this bench, my lords, for insisting
That
the
goes,
bench.
the moment goes and we forget. We never remember anything.
I'll do
Don't
it.
remember by pardon, seeking pardon,
I'll do it on Monday, my lords.
whenever. Tuesday,
Wednesday.
Wednesday.
Green bench matters.
Grateful, my lords.
Number 13, Mr. Arvind.
I beg to appear for the petitioner, my lords.
What is it?
My lords, the competent authority has rejected my application for grant of Quarry lease without giving an opportunity of being heard, my lords. My lords, the competent authority has rejected my quarry application for grant of Quarry lease without an opportunity of being heard, citing erstwhile rule 12(3), my lords. My lords, I am the first applicant for the said quarry lease area. However, the competent authority cites the erstwhile rule stating other applicants have gone priority.
Which is the order impugned?
Annexure A, my lords.
Annexure A.
Page number 28, my lords. The
28.
order is at page number 28.
Notice written.
Grateful, my lords. My lords, notice may be accepted for 1, 2, and 3 by learned AGM, my
Pardon?
lords. My lords, respondent number 4 and 5 are private respondents. 1, 2, and 3 are official respondents, my lords.
4 and 5 are?
Private respondents, my lords.
So solve them. Learned advocate, learned additional government advocate. Srimati Neelofer Court accepts notice on behalf of the 1, 2, 3.
Grateful, my lords.
The rest of this one shall be solved.
My
Shall we
lords,
keep it?
I may pray for one thing, my lords. Since there are rival private respondents, my lords, the department may proceed to grant order against the, in the favor of other private respondents, my lords. Status quo might be
What status?
that no precipitative action may be taken against me, my lords,
What
because
precipitated?
my lords, the other 4th and 5th respondent, my lords, are also seeking the same portion of the land. And their applications are being proceeded, my lords. Till my lords are
Your
here.
application is rejected on what ground, essentially? Page 28.
Yes, my lords. Lords, it's rejected on the
So
ground.
according to you, it is first in point of time, your application.
Yes, my lords. I am the first applicant, my lord, so. And they have proceeded to get NOCs for other applicants, my lords.
What is the date of the order?
The date of the order is
23,
23/4/2024, my lords.
23.
Annexure A order is at 23/4.
23/4/24.
Yes, my lords.
What is page 26, which is in vernacular language?
Yes, my lords, that's the impugned order, my lords, Annexure A. That is the
26th November 23.
Yes. My lord, I do not know if the directors are, has
How-
already executed the,
This is translation then wrongly translated. The 23rd is not the date. How come you file this? How come you mention this 23rd April 24. In the translated copy. On page 28, Office of the Director, Mines and Geology, number 49, Anija Bhavan, Racecourse Road, Bengaluru, dated 23/4/24. Now that date doesn't tally with the date of the.
Yes, my lords, I bow down, my lords. There is a error, my lords, in this. But it says, the seal says here 26
Should
now.
we bow down with the order? For misleading the court?
No, my lords.
What else it is?
It's not the case.
This can't be,
My lords.
can't be inadvertent mistake.
My lords, that is an inadvertent mistake, my lords. I'll correct that mistake.
So notice returnable on.
Grateful.
Come on, it's 17th, 17th of, now, 17th December.
Grateful.
December 14, Mr. T. Prakash.
Yes, Lord, I represent the petition, my lord. This is with regard to Pollution Control Board's order for closure of the petitioner's unit, my lord. The petitioner is a carpenter, my lord, a small-time carpenter is making the door frame and the window frames. My lord, the impugned order has been straight away passed without issuing any notice to the petitioner. An opportunity should have been given to us to explain if there is any air pollution or noise pollution. Well, all the neighboring owners, they have issued a letter stating that there is no noise pollution or air pollution. An opportunity should have been given that has not been given. Violation of natural principles of justice. Even in the order also, it doesn't show anything about issuing of the notice. Straight away passing of the order. In the reference column that could be seen, my lord, no notice. Page number 11, my lord, that is the impugned order.
Yes. You are not heard? Yes, my lord. You are there heard?
That's, I don't have the papers, but what I was told about the petitioners that, my lords, they're operating without consent.
Consent and.
So, my lords, the issue of hearing them may not arise. Though, my lords, of course, if they're operating, we should have heard them on first principles. So, my lords, at best, my lords, what I would request this court is that, my lords, let it be remanded back, but let them not operate until they're heard and their orders are passed. Because there's no consent which they have got.
My lord, my application is pending, my lord.
Please.
My lord, it does not cause any air pollution, my lord.
No, you don't have the consent.
Yes, my lord, I don't have the consent. My application is
They-
pending.
they-
Yes, that's a fact, my lord. But while
That has to be
passing the
first
order, my
spot.
lord, before passing the order, my lord, an opportunity should have been given to us. And my application is pending consideration. My lord, Rule 20A says, my lord, before passing this order, my lord, the
Natural
notice should have
justice
been issued.
operate in futility. Natural justice doesn't operate in futility. Futile.
Pardon, my lord.
Natural justice does not operate in futility.
That Rule 20A.
No point in giving you the hearing when you are admittedly not having the consent under the act.
So CJ would come into issue, my lords, when they have had consent, and how do we revoke it? Well, it's admittedly under the Air Act, my lords, opportunity must be given, even otherwise if it's not mentioned.
Lord,
But today, they don't have the consent.
Rule 20A, my lord.
Your application is pending.
Their application for consent is pending. My lords, this is my lords, just to recall.
What do you want?
Yes, my lord, Rule 20A says, my lord, before passing any order, notice has to be issued, my lord. Rule 20A, my lord.
Like,
Rule 20. Air pollution. control.
you are admitting that
Yes, my lord, there is no consent, my lord, but my application is pending consideration. Before that, my
that
lord,
can be considered.
yes, my lord, that could be considered.
That is an independent procedure, my lords. That has got nothing to do with what the petitioners before this court.
You're saying that application for consent is pending.
Consent
Yes,
is
madam.
pending. I do not know when he filed it also, my lords.
My lord, that we have
You have
enclosed.
to,
it-
like, disclose
enclosed
that
it to the
also.
petition. I have enclosed it to the petition also.
And after that, what activities, in fact, my lords, when he applies for
Annexure
consent,
G, my lord, Annexure G.
he applies for consent, my lords. It's a two-stage process where they get a
It
consent.
is not mentioned, applied earlier.
Annexure
submitted
G, my lord.
application earlier. Recently applied for pollution control. Copy of the application is the, what is the date?
Annexure G, my lord. May I request your lordship to kindly have a look at 20A, my lord, Rule 20A, subclass 3. It demands that a notice has to be issued before ordering for closure. 20A, sub-rule 3, my lord, Rule 20A, sub-rule 3. The person, officer, or an authority to whom any direction is sought to be issued shall be served with a copy of the proposed direction and shall be given an opportunity of not less than 15 days from the date of the service of the notice to file with an officer designated in this behalf of the objections, if any, to issue the proposed direction. And 4, where the proposed direction is for the stoppage or regulation of electricity or water, or for any other service affecting the carrying on of the industry, operation or process, and is sought to be issued to an officer or an authority, a copy of the proposed direction shall also be endorsed to the occupier of the industry, operation or process,
So
as the
what
case
learned
may be,
advocate
and the
Mr. P.
objection.
Prakash for the petitioner. There are this, your appeal,
Yes, my lord.
and learned advocate
Notice.
Mahesh Chaudhary, who appeared upon service of the copy of the petition in advance, or assist the court. Not to assist in advance. Invoking jurisdiction of this court paragraph, the article 2 basis of the constitution. The petitioner has sought to call in question order dated 21/10/24. Passed by respondent.
1 minute.
Start by respondent number 1, Karnataka State Pollution Control Board, whereby the industrial unit of the petitioner is ordered to be closed down. And the operations are prohibited forthwith and until further orders. The order is passed in exercise of powers under section 31 into brigade capitale of the air, into brigade prevention and control of pollution. Bracket over Act 1981 read with section 20 into brigade capitale of Karnataka air into brigade prevention and control of pollution. Bracket over rules 1983. The order mentions that the petitioner is engaged in the wood cutting and planing, PLAINing, planing. However, it is stated that when the unit was inspected on 23/7/24. Because inter-alia noticed that the operation of the unit was causing noise pollution and dust emission to the surrounding environment and was also causing smell as semi-double nuisance due to pollution activity. Inspection report of RO. What is RO? Regional officer, Kasarahalli came to be forwarded to the board, recommending the action against the unit by seeing closer direction under the provisions of the Air Act 1981. The Pollution Control Board referred the proceedings to the Supreme Court in the petition number 375 and the order dated 22/2/17 passed therein, as well as the order dated 8/5/13 passed by the National Green Tribunal in application number 37/13, which provide for taking of the action against such airing units. Paragraph. In course of the hearing, when the query was put to learned counsel for the petitioner as to whether the petitioner unit has got consent under the act, from a learned counsel for the petitioner was fair, FAIR, to admit that no consent is granted. Full stop. The order is passed on the ground of non-availability of consent, which becomes an admitted ground in view of this fair submission on part of learned of the petitioner. Full stop. Learned advocate for the respondent board would point out from the record that the petitioner has filed an application dated 12th November 2024 before the board seeking necessary consent.
And my lords, this annexure G is also, it's not in the format, my lords. It's a simple
He
letter which they
submitted
give.
that though by letter dated 12th November 24 is the the permission is sought for, the application is not in requisite format. Full stop. One aspect becomes clear that petitioner is not having consent to operate the unit. Secondly, the aforesaid application dated 12th November 24 was
Post facto.
filed just a day before of filing of the petition. Full stop. The conduct speaks for itself. Paragraph. In the aforesaid circumstances, no relief to the petitioner could be granted in this petition. Petition is devoid of merits. No.
So at least, my lord,
advocate for the petitioner would wanted to rely on Rule 20 capital A, sub rule 3, sub rule
3 million.
3 of the Air into bracket Prevention and Control of Pollution bracket over Union Territories into second bracket Union Territories bracket over rules 1983 to submit that hearing was necessary before taking the action. Full stop. This submission falls flat when is an undisputed position that the consent is not available to the, is not granted to the petitioner unit. Full stop. When there is no consent and the non-availability of the consent is the ground for closure, giving open hearing would be a futile exercise. Full stop. The principles of natural justice does not operate in futility. The doctrine of futile exercise will apply. On that count, the submission that the hearing is not given is of no consequence. Paragraph. No relief in the circumstances could be granted to the petitioner, except observing that if the petitioner makes an application for obtaining consent in accordance with procedure and in requisite format by paying necessary fees, etc.
Yes, ma'am.
The board shall consider the same strictly on merits and in accordance with law. Expedient.
This blood time frame is fixed, my lord.
Preferably within 8 weeks.
6 weeks.
3 weeks, my lord.
Okay.
Preferably within 8 weeks.
4,
8 weeks.
4 weeks, my lord, because the industry will be closed down, my lord. That is the reason. It's a small time carpenter, my lord.
We just filed it 6 weeks. 6 weeks. 4.
Number 15, Aditya Narayan.
This court order does not express anything on merits about such application.
I beg to appeal for the petition on it.
My lord, I appeal for the respondent number 4 and 5 in this matter.
What is it about?
Lords, this challenge, my lords, is to a penalty that is imposed, my lords, by the DMG on account, my lords, of non-commencement of production activities in the mining lease. My lords, the petitioner, my lords, before your lords, was the auction purchaser, my lords, of a C category mining lease. And in terms of, my lords, the orders of the Honorable Supreme Court, under which the auction was held, and also, my lords, in terms of the statute itself, the petitioner became entitled, my lords, to the transfer of the forest clearance, which was given to the erstwhile lessee, my lords, of that lease before it was cancelled by the Honorable Supreme Court. Lord, your lordships will recollect, my lords, these leases in Karnataka were categorized into 3 categories by Honorable Supreme Court in the Samaj Parivartan Samuday proceedings. And the C category leases, my lords, were cancelled and directed to be auctioned. In, my lords, those orders directing auction, my lords, there was a direction to transfer the lease, the forest clearance. Lords, the state does not do that. I'm sorry, my lords, there is a penalty that is now imposed on me by way of the impugned order at page 55. Under which, my lords, I'm called upon to pay 50% of the minimum guaranteed dispatch on the ground, my lords, that I am not commencing the production within, my lords, a period of 18 months from declaration of me as the successful bidder. My lords, in fact, the only reason I could not commence the production, my lords, was because the state did not transfer the forest clearance to me. And, my lords, this issue is covered by your lordship's judgment in another case, my lords, where your lordship's, my lords, held that where there is no transfer, then such a demand would not lie. If your lordships kindly take the judgment at page 308, my lords. In similar circumstances, my lords, where that lessee was entitled to the benefit of transfer. Your lordships are page 308. Minutes.
Page
308 minutes.
308.
Please, minutes. This is the judgment of 27th September 2023. Lords will kindly see, lords, at paragraph 4 at page 319. The state took a similar stance, lords. If your lordships kindly see paragraph 4 minutes.
We were paid the part of the amount also.
Please, minutes. Because, my lords, what was happening was, there was a time limit of 5 years, within which, my lords, under the rules of the mining lease is not executed. Then, my lords, the entire process gets annulled. So, my lords, since that 5-year period was coming to an end, I paid it, my lords, on a without prejudice basis. And then, my lords, approached your lordship's court. In as much as, my lords, I am entitled to a transfer of the forest clearance. The state, my lords, deprives me of that transfer, requires me, my lords, to file a fresh clearance application. And, my lords, that clearance is given to me only after 4 years. Then, my lords, at that stage, because the LOI is limited to a term of 3 years, my lords, I approached the state requesting for extension of the LOI. Whilst, my lords, granting that extension, my lords, for the first time, this levy is, my lords, sought to be saddled upon me. Let's kindly have a look at 2 paragraphs, my lords, of the judgment. Lords, it's fully covered, my lords. In fact, it was the exact case that was taken by the state government in that case also. If your lordship, sorry. The paragraph 4 and 22 of that judgment, the case of the state is identical, minutes. that I did not commence production. And that, my lords, in that case also, they took the stance that since the lessee moved an application fresh clearance, the lessee had acquiesced, my lords, in not insisting on transfer.
This will cover or not the?
It will not cover notes. We have, let's kindly see the operative portion of that. It will not cover in terms of the, kindly see the operative portion.
Lords, may I only place one more fact, my lords, just so that, my lords, the entirety of the facts is before your lordships. Pursuant to this judgment, my lords, in that case, the state, my lords, took a decision not to insist on payment of the penalty and proceeded to execute the lease deed, my lords. I produced that material which I obtained under RTI, my lords, by way of a subsequent memo, my lords, before your lordships. So in that case, the state has fully accepted, my lords, this judgment and acted upon it. That's all I wanted to say.
Let's, insofar as the MSPL case is concerned, that covered by judgment they're referring to, let's letter of intent was sought to be invalidated, my lords, show cause notice was issued. At that stage, my lords, they have approached this honorable court. Here in this case, my lords, letter of intent, that was a case of transfer of forest clearance. This is a case, he applies for a fresh forest clearance, he pursues it, and he gets a fresh forest clearance. Letter of intent extension is subject to the payment of minimum dispatch guarantee, and he accepts that. Mining lease also is executed. In the mining lease, there is a condition. He accepts that. After that, he files this petition. Kindly see the mining lease, my lords, at page 395. He has accepted the mining lease with that condition, 395, my lords. It starts at 386. Para 13, my lords. Lessee shall produce and dispatch the iron ore.
This is minimum production.
Please, my lords, this amount is in challenge. He takes a letter of intent is extended with the condition that he will pay this amount in terms of the Supreme Court judgment. This is, my lords, a condition imposed by the Supreme Court. It's not, my lords, in the either in the statute or the rules. And after executing a mining lease, thereafter, my lords, he files this petition. Mining lease was executed on 5/10/2023. He files this petition on 7/3/24. In the meantime, letter of intent was extended, my lords, subject to this condition. He accepts that condition. Then subsequently, mining lease executed subject to this condition. He accepts that condition. Then, my lords, after that, after 6 months, he files this petition, and his is a case of fresh forest clearance. He applies for fresh forest clearance, pursues it. And, my lords, finally, letter of intent is extended. My lords, this is the Supreme Court order on the basis of which, my lords, this condition is being imposed. That is at annexure, page 59. Page 59 is the Supreme Court on the basis of which this condition is being imposed. It starts at 59. Page 63.5, my lords. Page 63.5. Next page. My lords, are page 60, my lords. Condition 3.5 minutes, para 3.5. The successful bidder lessee will be required to produce and dispatch every year at least 50% of the permissible annual production as prescribed under approved R&R plan. Whenever the dispatch in a year is below the guaranteed dispatch as indicated above in that case, irrespective of the quantity actually dispatched, the total amount payable during the year will be based on the guaranteed dispatch. In addition, the lessee may also be required to surrender the lease. This condition will not be applicable during the initial period of 18 months provided to the successful bidder lessee to obtain the statutory approval. Now, para 4, my lords, the above conditions will naturally be in addition to all requirements spelled out by the amendments to the Mines and Minerals Development and Regulation Act 1957 and Mineral Auction Rules 2015. Now, the impugned demand at page 55.
Look, since your lordships are on the order, kindly have a glance at 3.8 also.
I'll just-
My learned friend should also read that.
I'll read it. The existing statutory approvals clearance in favor of lessee of the erstwhile category shall be transferred in favor of the new lessees. The authority concerned will take expeditious action for grant of statutory approval such as environmental clearance approval, so and so. Now kindly see 55. And in MSPL case, it was a case of transfer. Here it is not, it is not a case of transfer of forest clearance. It is a fresh forest clearance he goes for from 2019.
Are you going to any action against?
Please, my lords.
Are you going to take any overseas action?
My lords, they are depositing the payments in terms of the, it is subject to, made subject to the result of the writ petition, my lords.
Lord,
The
so far I had paid.
Five installments have been paid, 3 more are left.
Lords,
out.
may I only make one
Let them
submission?
complete and
Lords?
we-
Your lordships may kindly have a look. My friend says MSPL's case was not a case of transfer. Para 22 that is directly dealt with.
Down, setting now, repeated, heard, learned advocate, senior advocate, so and so. For the appellant and learned additional record.
Please, my lords, Ruben Jail.
So and so for the respondent. Appeal requires final hearing, is admitted to be posted in the second week of March 20.
Lords, in
Yes,
the meanwhile,
great.
I'm sorry, my lords.
In the
So
meanwhile,
may I
once it-
seek this indulgence, my lords? My lords, in the meanwhile, my lords, I've already paid 6 installments. My lords, it's a huge amount of money. I invested 100 crores in this lease. Kindly just have a glance at 2 paragraphs of MSPL's judgment. My lords, I'll place it for your lordship's consideration. My lords, the entire purpose of acquiring this lease as a captive lease, my lords. Actually, if we work out the costing and add this penalty to the production, my lords, I'm better off not having got the lease.
18 crores you have paid.
My lords, I paid much more than
Much more.
18 crores. My lords, I paid nearly 45 crores.
45. My lords, the
I
tot-
paid 45
only
crores
3
out
more.
of 72 crores of the demand, my lords. Let them hold their hand in respect of the balance, my lords. I have showed my bona fides by paying to them directly.
This
My lords,
submission
it's
was,
squarely covered.
Pay something and we'll.
my lords, this submission,
My lords, I have already paid 45 crores. My lords.
my lords have already made an order that any payments will be made
That's
subject to the result of the.
No
request, because
difficulty, my lords.
this
In fact,
argument-
I moved an application, my lords, in light of that order.
The total amount of penalty
72 crores, my lords.
imposed on the petitioner, which is sort to, which is under, which is called in question. Which is subject matter of dispute in the appeal is to the tune of rupees 72, 20, 74, 552. It was jointly submitted that it was undisputedly submitted that the appellant has paid rupees 45 lakhs.
Please, 45 crores. my
Crores.
lords.
45 crores approximately
Yes, my lords.
towards the said demand of penalty. Full stop. As learned advocate for the, as learned senior advocate for the appellant presses for interim leave, it is directed that The respondent authority shall not take any coercive steps against the petitioner, provided the petitioner pays further sum of rupees 10 crores.
Lord, could it be the 8 crore, my lords, that I was to pay for this quarter? They're taking it quarterly. As of October, I had already paid 8 crores, making it up to 45 crores. Your lordships may grant me that next quarter I'll make that payment, my lord.
10 crores within 3 months. Please.
Very well. I'm deeply obliged.
Grateful.
Lords, I'm sorry, my lords, your lordships may kindly say advocate for the petitioner.
Pardon?
Advocate for the petitioner. I'm appearing for the petitioner. Lordship said appellant. There's a
Sorry,
repetition.
wherever appellate is that petition.
I'm
My lord, one
obliged.
submission, my lord. My lord, one submission, my lord. I am for the respond number 4 and 5, my lord. My lord, the
Lord,
petition,
follow.
the petition may be
clear.
directed to produce the EC, my lord, environmental clearance.
My
That is one of the
friend,
conditions.
Who is number 4?
my lords, the union, my lords, Ministry of
Union.
Environment and Forest, Union of India.
So you are heard to learn additional record general,
Please, my lord.
namely claimant, who appeared and made submissions to video conference.
I'm deeply obliged.
Much obliged, my lord.
Fresh rate appeals, seal number 16. Tarish H.V.
Lordships, 5 days delay in filing the appeal. And in the meantime, Lordships, some of the documents which were filed before the learned single judge is a misplaced, my lord. I have not filed it along with
5
this.
days delay, everybody is appearing,
No, my
Third
lord,
learned.
this respondent 41, 42, 43.
then serve. Notice,
They need to
be served.
notice. I will serve it, Lordships, if you are.
Served,
Yes. I shall serve it, Lordships.
notice to the respondents,
41, State of Karnataka, 42 VTU, and 43.
notice to the respondents,
ACT
returnable on 7th January. Respondent 41 and 42 only shall be
42,
required.
43 also.
41 to 43 only shall be required to be served, since learned advocate Ms. Vaishali Hegde and learned, we appear for whom?
Please give it, please,
Caveat.
For all others,
for all others, for
For
all the
rest of-
private respondents
appearing caveat,
from
accepts notice on behalf of
1 to 40.
the rest of respondents.
A week's time, my lord, I will serve it.
7th January.
Seal number 17. To Karthikeyan BS.
Appellant in this matter, my lord. The respondents have filed 2 applications. Respondents have filed 2 applications. For production of additional documents.
My lords, I have filed an application, my lords, for additional documents, IA 7. My lords, IA 5 is for pleading myself as a respondent, my lords, in these proceedings. ಸ್ವಲ್ಪ My lords, I have filed an application. My lords, that application has to be allowed for impleading, my lords.
Not a party before the learned single judge.
That application is allowed, sorry, my lord. That application is allowed, but
Additional documents can be considered while the matter is being heard on merits minutes. But I think that they have served the copies minutes on the
file, sir.
appellant. But I was the writ petitioner minutes, and if they are having any conflict of interest with me, they'll have to serve the copies on me. Notes,
No, file, sir.
but the BDI will have to now make out a case minutes, because the learned single judge has returned a categorical finding that BDI has passed a resolution in favor of the society pursuant to the directions which was issued by the coordinate bench of this honorable court. Notes, our only grievance before the learned single judge was only against the government, because the government said that we are not approving the decision taken by the Bangalore Development Authority. Not the learned single judge has returned a finding saying that under the scheme of the Karnataka Town and Country Planning Act, government has no role to play insofar as sanction of plan is concerned. So therefore, that order is not valid.
We'll hear some other.
Lots is there. This is pertaining to Karnataka Judicial Employees House Building Cooperative Society. There are various peoples to whom the allotments were made, and they are unable to utilize these properties, and the society is also under tremendous pressure for the fact that the coordinate bench permitted that whatever is the shortfall in the areas which should have been earmarked as CS sites and the parks, that will have to be compensated by payment of certain amounts. This was what was observed by the coordinate bench. Now, whatever that area is, which is allotted across the entire layout, they are not in a position to enjoy. I'm only making this fervent request so that your lordships may fix an earlier date, Rest I'm in your lordship's hands.
Your date. January,
I'm in your lordship's hands.
8 January.
Lordships.
Much.
So number 18. Mr. Manjunath RV, party in person.
My lords, appearing for the respondent, my lords.
Register.
Your Lordship, kindly allow me
Now,
appear as a party in person for this writ appeal. And there is a delay in 62 days, my Lordship.
Lot certificate is there. Competence. Say form C issued on 29. Candidates or not shifted to other candidates.
My Lord, this writ appeal is filed, being agreed by the implementing order dated 30th October, my Lord. I was an applicant for the SDA at the High Court of Karnataka. SDA post at High Court of Karnataka, and under ex-serviceman general merit category. There was total of 13 vacancies were allotted for ex-servicemen, my Lord, out of which only 11 was considered and mentioned as 2 vacancies for category 3A and 1 vacancy of SC has been given to other person due to non-availability of the ex-servicemen. I have filed a writ of petition for the same to transfer 1 3A category post to the general merit category and accommodate me for the subject course. Being unsuccessful candidate in one subject, I have requested the Registrar General and wrote many letters, Honorable Chief Justice also, my lord. Thereafter, not only consideration of my candidature, I have requested them to fulfill all the vacancies as per the relaxation given by the legislature and the parliament for the ex-servicemen for coping up the special reservations with other people. When they have, there is no response, I have filed the writ petition for myself to consider me for the subject post under relaxation given by the state government under Karnataka Services Rules 1977 3A. But the respondent has given the statement, has filed the statement of objection, my lord. There is a contradiction to the contents in the whole statement of objections. Once the respondents say that the whole recruitment process has been conducted strictly under Karnataka High Court Rules 1973. And they are saying that no relaxation has been given. And in one paragraph, they are saying that the ex-servicemen who are also not in the position of graduation certificate also considered. The whole statement of objection is contradiction to each other, my lord. And while preliminary hearing, even I have quoted about the judgment of Anil Kumar Gupta versus UP of the Apex Court, my lord, for accommodating the special reservation people. Due to all these things, my lordship, I have filed a writ appeal.
Who appears?
My lords, appearing for the respondent, my lords.
Yes, whatever to say.
My lords, recruitment was carried out in terms of the High Court rules, my lords. And also all the posts were filled, my lords. In the writ petition, my lords, we have filed statement of objections contending that the petitioner did not pass the eligibility test, my lords.
Come physically and argue. You can't
Please.
argue in online. You are from Bombay?
No, my lords. Sorry, my lords.
No. Then where is the question?
Please, my lords.
When you will come? 28, 29 December, 11th December, whenever. Whenever you want to come.
My lords.
Tell your date.
My lords, 5th December, my lords.
5th December, not possible.
My lords,
Hold at 5th December. 5th December.
Appear for the appellant. I sought for the relief of stay of the impugned order passed by the tribunal dated 18/10/2012 in LRF 945/1187 and 14/18 of 75/76. For the reasons, my lord, the property belonged to Ramalingeshwara Matta, headed by one Chandramala Shivachara Swamigulu of Sri Ramalingeshwara Matta.
the tribunal has that tenants have not made a party in that LRF. My lord, the history of the matter is that one.
You want us to pass the order without papers?
My lord,
You,
I got papers. My lord.
you must have papers. Arguing without papers is insult to the court. Yes. What is the matter?
My lord, I sought for the stay of the annexure W in writ petition. Page 525, my lord. In the second volume.
Release the notice. Notice.
I'll take notice for respondent number 4 to 6, my lord.
Come Rising out of same. So you go through the, this is in writ appeal number 356, 2024. Then we'll consider.
Writ appeal?
356 of 2020.
My lord, that appellant has filed writ petition 27728 of 12 for quashing of the impugned order passed by the tribunal. This honorable court was allowed and directing to remanded the matter for fresh disposal. Thereafter, the tribunal has not entertained me in that proceedings, my lord. Against that single judge, the honorable single judge order of this honorable court filed a writ appeal 6945 of 12, in which this honorable court was dismissed, holding that the order passed by the single judge is right, appropriate. Taking advantage of this order, the tenants have influenced the office of the revenue and got changed the kata from the name of appellant in favor of that tenants, my lord. That writ appeal was not in their favor, my lord. That was dismissed. In spite of that, they changed the kata, which was stands in the name of appellant, for which I have filed a contempt petition for disobeyed the very order of this honorable court. Formally, my lord, the court, office of this court insisted me to take a permission from the Advocate General. I filed a case before Advocate General, in which the Advocate General passed an order. High Court has not authorized him to do so, to change the kata. You can go and file an application for rectification of the defect committed by the revenue authorities. Therefore, I made several times to change the kata. They were not turned up, my lord. By this time, by that, in the meanwhile, the order was questioned by another writ petition that was dismissed. Immediately taking advantage of that dismissal order, that tenants hurriedly, violently changing the land, leveling with 3-4 JCPs and taking a possession without a rule of law, my lord. That My lord, earlier, the Matadipatis, he handed over this property to government on condition whenever in future Swamiji asks, government has to return, for which the government return this property in favor of the appellant. When this is a inam land, cannot be treated under land tribunal, my lord. It not comes under land tribunal. The tenants were not made an application earlier to 1/3/1973. Therefore, the very application of the tenants and the tenants were not actual cultivators, my lord. And the tribunal cannot bifurcate the land to the two tenants, 16 acres, 16 guttas, one claimant, another 16 acres, 16 guttas, another claimant. But in survey number 72, total 33 acres, 18 guttas, my lord. How in law, the tribunal cannot bifurcate and allot the land as if their own land. The application filed for entire land in survey number.
So what is your appeal?
My lord.
We'll consider. 13. 13. Come on, 13. Yes.
Till number 20, Mr. Sanjeev BL.
Yes, my lord, the corporation had challenged the order, my lord. In the meantime, the enactment has been passed as per the direction of the Honorable Single Judge, my lord. The contempt has been filed, my lord. It may be called along with the contempt matter. My lord. Contempt has been filed by the respondent.
After vacation. You want to place contempt?
The contempt has been filed by the respondent. We have already passed the endorsement.
Notice written. 9th December.
One urgent, still number 22, Mr. Krishna S. Vyas.
Appearing for the appellant, I'm sorry, because of my indisposition, I am appearing online, my lord, sir. My lord, sir, it pertains to a land acquisition matter in which, my lord, sir, the learned single judge has passed an order on 17th November 2023, my lord, sir. Thereby, my lord, sir, dismissing the petition which has been challenged before this honorable court. The contentions of the petition appellant is that, my lord, sir. My lords,
February 17. Notice.
my lords, in the meanwhile, there had been an interim order which I had been enjoying even before
There is a delay of 288 days.
a status quo, my lords, nothing more than that.
Pardon?
A status quo, my lords, in order to.
Then there is no delay.
Because the petition, any disturbance, my lords, the petition would be appeal would become infructuous, my lords. Therefore, a status quo, my lords, nothing more than that, my lords.
23 minutes, kindly pass over.
Lordship, I'm for the respondent.
There is a delay. No interim order can be passed. We can keep it early, 19th, 18th of December.
May I make a mention? Serial number 65, my lord, I appear for the petitioners, my lord, some inconvenience in the afternoon. I request for a short.
February 11.
That is serial number 98, it pertains to election matter. Election is going to be held on next Sunday, day after tomorrow.
We'll take up.
My serial number is 100 and I got an order in my favor, but they got it straight in April, after that they're not coming. And it happened just 10 minutes after I make my submission.
In line, only in period.
Well,
Serial number 102 for withdrawal of contempt, Mr. Jagdish J.R. Mr. Jagdish J.R.
Memo dated 8/11/24, filed by learned advocate J.R. Jagdish for the complainant. Figures on record in which it is stated that the respondent has complied with the undertaking made before this court, by virtue of which the grievance of the complainant is redressed and the khata is registered in his name. Request is made not to continue the contempt proceedings. In the aforesaid view, contempt petition does not survive. It is dismissed as not surviving.
Number 104. Mr. J.R. Mohan.
That's, may I pray for a 10 to 15 minutes passover, my lords? I have my report ready. It's getting notarized. I'll place that on record and make me
What is
submission.
it about?
1311 order.
Oh.
The affidavit is ready from BBMP side, my lords. I'll be placing it on record. Affidavit is ready from BBMP side. I'll be placing it record 10, 15 minutes time if it's granted. It's getting notarized as we talk.
So now you will need time. You will need time. Learned advocate Mr. Prashant files affidavit, further affidavit, which is taken on record. You we are filing today. Learned advocate Mr. J.R. Mohan. Raise for time in view of the filing of the further affidavit, stand over to. This is what, this is that Vishwavati.
Yes,
Hello?
yes.
Huh?
My lord,
Okay.
I'll have to file my affidavit.
File it. Cover offending.
Any day, my lords. I'm
13.
ready today as well.
13.
Obliged.
Yes, my lords.
13. 13 December.
July 2022. They have to respond. Subsequently followed by revocative order on 29 July.
We have sufficiently taken them to task.
Yes, my lords.
Now we let us see what they are.
And the officers have also taken it very seriously and the affidavit will be apparent on that record.
Not that they are not.
Last weekend, I filed a memo showing that the course of that, it was river. A fuel school building was constructed within the, was one only, photograph, and the media had given a report also. State also, they given a report. So they are all, they have all those things.
They are all.
They have to see that removal of enforcement because the BBMP Act itself provide under section 340. Our new act, which has been now 344 is very clear. Prohibit no person without authority in the field, remove or asset or other matter of deposit any matter or make any encroachment from in or any land vested in the corporation or water courses not be private property or in any way obstruct the sale. So these are all the water courses. All these things, basic things, because now we do have.
Yes,
Let them examine and come back to this. That's all we want, because we are only concerned with the removal of. Further tax.
Yes, my lords.
103, so S.Y. Shivali, please.
In the case. In this case, not the petitioner is before lordships for seeking writ of mandamus against the competent authority for considering his application filed for seeking grant of quarrying lease. In response to his application, already grant notification is issued. Grant notification is issued. That is at page number 48. And which was not withdrawn subsequently. Then challenging that withdrawal order, I filed a revision petition before the additional director of mines and geology. The director set aside the cancellation order and allowed my revision petition directing the competent authority to consider and to take decision. This order was passed in the month of December 2023. Even now, they have not taken any steps. But on the other hand, recently they have written a letter to the deputy commissioner to get opinion of revenue department. But fact that under the rule 8(5), not already assistant commissioner has submitted his no objection as well as its opinion to grant lease in my favor. But this the annexure N page number 98, which has been written just to delay the proceedings and to avoid execution of lease in my favor. Therefore, I am before lordships to issue a direction against the respondent authorities to consider my application produced at annexure B for execution of lease. In fact, he has complied with all compliances as required under the rule. As per rule 2023 and rule 8B, wherever NOCs and technical report is issued, those applications shall be considered and lease to be executed. That is what the rule says, rule 8B proviso. But
I'll reply.
My lord, I have received instructions. Since my lord had directed me to take instructions from the concerned officer, my lord, he's expecting the no objection certificate within a month from the DC revenue. So if my lord were to grant us, my lord, about 10 weeks time, my lord, we will consider that representation. My lord, I'm sorry, my lord, I just have one copy. Last paragraph.
may I make submission? The fact that getting NOC from deputy commissioner in the instant case is not at all required, is not necessary, for the reason that the petitioner has filed application for grant of quarrying lease in respect of non-specified minor mineral. In the case of specified minor mineral, the deputy commissioner role comes into operation mode as per rule 8(5) subclause 1. Not kindly peruse rule. Sorry.
Rule returnable on 27th February. We are admitting the petition. Rule returnable 27th February.
List number 2.
We are admitting the petition.
Case of may be disposed of. It may be disposed of in terms of not a submission. Otherwise, no need to keep the pending.
Let's choose the better option, better or less.
This order
My lord, that pertains to the first writ petition, my lord. Then for the petitions 103.1 and 103.2.
We'll say, Mr. Counsel, that pursuant to last order, the learned additional government advocate has taken instructions and produced on record copy of this letter. In view of the, you give.
My lord, that is,
copies.
my lord, this is my.
Not producing.
No, this is my information that I got since my lord had directed me to seek instructions.
Can we not record?
No, I'm just producing this for my lord's this thing.
So shall we keep it in record or not?
My lord may keep it on record.
So in
My lord,
light of-
and 103 and My lord, I don't want
Right
that.
of what is
This
contempt.
is addressed to me, my lord.
So you better wait, they are going to grant, it appears.
We will consider.
It appears that they're going to grant. If you want to wait, then we'll adjourn the matter.
Short date.
Short will not do this, they're.
My lord, for the first writ petition, they are seeking for a month's time, but I am requesting for 10 weeks. My lord, for 103.1, 103.2, and for 57, they are requesting for 3 months' time, and I'm leaving it to my lords.
Let my learned friend make submission only in so far as WP number 27961. First, that may be disposed. As per learned friend seeking 10 weeks time, it may be disposed of within 6 or 8 weeks. Because it's 2015 application. This is third round of writ petition.
There is an extra N.
My lord,
Next
page
page.
102.
198 Kannada, 101 in translation. 101.
101 is the one, 102 is where my lord will have to see. Third paragraph.
So this letter you are producing today is in connection with page 102.
Yes.
Please.
Then. Hard learned advocate Mr. So for the. Then learned additional government advocate Srimati Neelo Farakpar for the respondent state and its authorities. Invoking the jurisdiction of this court under Article 2 of the Constitution. The petitioner is free to direct the respondent authorities to grant, public execute the release in favor of the petitioner within the time limit prescribed under Rule 8 capital B in bracket 2 of the Karnataka Minor Mineral Concession Rules 2023 to extract ordinary building stone. That's the non-specified mineral, in respect of 10 acres of land, which is government Gairana, Gairana, Gayrn, Gairana land bearing survey number 196 of 196P into bracket of Kadabi village, KDABI, Savadatti Taluka, Belgavi district. As per application dated 14/8/2015, filed by the petitioner. On the record of the petition and communication dated, copy of the communication dated 24th January 24, addressed to the Deputy Commissioner, Belgavi District, by the Deputy Director, Mines and Geology Department, Belgavi, in which following is stated inter-alia. Page 102, bracket report under Rule 3 like quarrying activities. In light of the above aspect emerging, paragraph, and the petition was taken up for consideration on the last occasion, on 12/11/24. the court required learned additional government advocate to take instructions in relation to the grievance of the petitioner. In particular, with reference to the aforementioned communication dated 22/24 into bracket at annexure N, page 101, case 102. Bracket over. Today, when the petition came up for further consideration, learned additional government advocate produced on record copy of took instructions in the matter and produced on record copy of communication dated 19th November 24 from the office of the Deputy Director, addressed to the additional government, addressed to the government advocate, in which it is inter-alia stated that communication is already sent to the Deputy Commissioner Belgavi in accordance with Rule 8 into 5 of the Karnataka Minor Mineral Concession Rules 1994, which would be issued within 1 week. It was stated that no objection certificate from the Deputy Commissioner would be expected, is expected within 1 month. Full stop. In light of above internal correspondence, it would be gathered that the application of the petitioner is being considered by the authorities. Full stop. In the above view, without entering into the merits of the case, this court directs respondents to work through the competent authority to decide the application of the petitioner. Within 8 weeks from today. That's it. Not. It's a parallel in the aforesaid letter. It is interpreted that the authorities will proceed with further processing of the application in accordance with law. Once no objection certificate is received from the Deputy Commissioner Belgavi, it is expected within 1 month. We have written what is written here. Certificate is expected within 1 month.
1 month. That's the reason why I asked for my lord, to avoid any contempt proceeding.
This order not,
Disposed of accordingly.
this order pertains to first writ petition, 27964, sorry, 27961, first order is concerned. This
Once clear, the other will be also.
please. Next two writ petitions, my lord.
My lord, in that also
10.
I have instructions to
Same.
say that if 3 months' time is granted, my lord, then they will consider and dispose of the application.
Same subjects.
First one is concerned with government land is concerned.
Oh,
These three writ petitions are concerned private patta land. There also not notification issued, quarry license, quarry plan.
simply we will say decision within 3 months.
No.
They will decide the application within
3 months, my lord.
10 weeks.
My lord, I don't want contempt petition to be.
3 months. Without going into marriage, 3 months.
No, please.
Obliged.
Serial number 57 also.
57 also. sir.
This. But petitions are different, server numbers are different, but issue number is one and the same.
Obliged. ma'am.
This was 51.
57, my lord.
57.
103.1, 103.2, and 57.
57. This was 57. Now this is getting disposed of. 57 is getting disposed. Only 50, sir. वो तो dictate किया हुआ है, 10. What is dictated is 1011. That is 1.1. Then what will other matters will be the other connected matters?
Facts.
103/1.
Is dictated now. 103.
103 dictated, not 101. So 101 dictated, 103.1 and 103 is similar.
And 50,
And
sir.
50 is.
List number 2. Complaints in contempt matters. List number 1, Mr. Sina Pake.
We have complied this
Second one.
It's come,
this matter, my lords. We have filed the affidavit also,
complaint,
OD and the rest.
complaint,
Complied with.
complaint, they have done podium to rest.
Learn and revocate. Learn and revocate, Mr. So and so, so will be petitioner. Sinappa, okay, for the complainant and learn and additional government. Stated that the order in the contempt is come to speak, in the aforesaid view, has nothing survived in the contempt petition, it is disposed of it accordingly.
2 and 3 also.
Similar
Number
matter.
2 and 3,
Same,
same.
same. Very good.
Still number 4, Mr. Balraj AC.
Lord, I appear for the complainant. Government has to file counter.
My lords, my affidavit is ready, my lords, sir. I may be permitted to. We have already complied, my lords. The affidavit has been filed to that effect, my lords.
Government has to file counter affidavit. Today they are serving, my lord. I pray for some time.
Comment is filed.
Now they are serving the copy, my lord, by the government.
We are
Pray for a
saving,
week- I pray for a week's time, my lord, to look into and make some.
Week, why week? What is it?
my lords. And for the accused number 1, my lords.
My lord, they have not complied with the direction.
My lord.
Direction was, my lord, to consider a claim, my lord, for granting retrospective promotion, my lord, from the date we are placed in independent charge of the post of assistant executive engineers. What now the affidavit is filed with an endorsement saying that they want to finalize the seniority list and thereafter our claims will be considered. That is not complaints itself, my lord. The court has specifically granted the learned single judge to consider our claims in pursuant to the government orders issued from time to time. That action they have not taken.
Lords, I want to take your lordship to page 12 for a moment, my lords. What was the order passed? The learned counsel for the petitioner submit that as a matter of fact, the government itself has issued an order on 17/10/2023 whereby he would be entitled for grant of retrospective promotion. Petitioner is permitted to submit the said government order also by filing a fresh representation, and the respondent 1 and 2 shall consider the effect of this government order and the representation while passing the order. After subsequent to this, my lords, he has given representation, my lords, by quoting this order. Thereafter, on 26/3/2024, we have issued an endorsement. That endorsement I have produced along with the
Kindly
affidavit.
see the endorsement at para 14 and 15, my lord. Page number 10. Page 10 of their objection. In the light of the facts and circumstances, the issues of finalization of seniority of the cadre of assistant executive engineer requires a thorough examination in the light of direction given by the Honorable High Court of Karnataka in order dated 9/11/2023 in the WP number so and so, filed by Sri Jagdish, that is the complainant, and also the clarification issued by the state government in communication dated so and so, and also the rules governing retrospective promotions issued by the state government, and also all issues connected with finalization of the CNT list of the cadre of assistant executive engineers of the board. In view of the above, the general issue of finalization of CNT list of the cadre of assistant executive engineer is under the active consideration of the board, and it involves a determination of seniority of hundreds of officers, and the representation submitted by the so and so dated 25/11/23 will also be considered.
will also be considered. They are not considered.
Lots there
And
are,
along with the other connected issues, and then taken will be communicated to the petitioner in due course. The
That's-
interim endorsement is being issued in the light of the order dated so and so. Only to Malad to safeguard their, to safeguard themselves, Malad, this endorsement has been issued. They
there are
not actually
subsequent
considered.
developments, my lords. The directions which was issued by the government was challenged before this honorable court. And there is an interim order against that direction, my lords. That is what the affidavit I have filed. So now there is no contempt. I have produced along with the
Disposed of. Give your appearance. Dismissed.
Liberty may be reserved to, liberty may be reserved, my lord, to challenge those endorsements, whatever they have.
That we. In accordance with law,
obliged.
for which we do not express any opinion.
Mhm.
This is remember. One not. Four. One not four. What is four? Yes.
Seal number 5, Mr. Bhaskar CR. Seal number 5,
Here again, we have filed our compliance affidavit and complied the orders.
Where is the council? Yes,
That's
Monday.
Af-
Second one.
seal number 6,
I appear for the complainant, my lord, in this case.
Hmm.
The para 13 of the judgment is not complied, my lord. Para 13 may kindly look into. Page 22, in page, internal page 11. In that view of the matter, I am of the further considered opinion, the respondent number 1, Principal Secretary, Department of Revenue is required to hold necessary inquiry into the matter to ascertain and fix the responsibility of the persons responsible for violation of the application of law. That has not been done. Within 90 days after hearing the concerned.
So even finally,
Directions are at page 12, internal page 12, page 23 of the writ petition.
correct, page 20. Yes, what is your saying? Not complied?
Lots, if I may point out the compliance, if I may point out the compliance, my lords. The second direction, my lords, that is the rectification of the kata, 84 feet into 60 feet. Lords, that it is rectified, my lords, in the paragraph 4 of the compliance affidavit, page 3, my lords. I've also produced the kata, my lords, wherein it has been rectified, showing it as 84 into 60 feet.
But all other directions this is complied except that one, my lord, para 13.
And the next direction to submit 10,000 rupees as
That
from
has
their
been
pockets.
complied, my lord.
That has been-
That has all complied. Except para 13 of the judgment.
So they are complied with.
Yeah, all other complied, my lord, except 13 is not.
It is only in form of observation, my lords. Paragraph 13 is my respectful submission. Major substantial compliance has been done. It's stated in the compliance affidavit in paragraph 3, 4, and 5 minutes.
Specific time is also given, my lord, 90 days
So nothing survives.
to hold inquiry.
Mr. Counsel, nothing survives in the complaint. Contempt
But the
petition.
domestic inquiry is not conducted for their irregular activities. That is what the learned single judge passed.
So dispose of.
Please.
Learned, or learned advocate, Mr. So and so appeared through video conference for the complainant. Home and learned additional advocate, additional home and advocate. Srimati Pramodini Kishan for the respondents. So, Mr. Counsel, all directions are complied with.
Yes, my lord, all other is complied except that one holding domestic inquiry is concerned.
It's only in the opinion, my lords of the honorable court.
90 days time is also fixed.
All so and so, full stop. The operative part of the order dated 25th October 2023 of learned single judge contained the following directions. One, 2, 5, page 23. Is green flap. While not disputing the compliance of the above directions from a learned advocate, Mr. Soans, learned senior advocate, Mr. So and so appearing the video conferencing submitted that in paragraph 13 certain that what is contemplated in paragraph 13 is not complied with. Paragraph 13 reads as under in court paragraph 13. It was therefore submitted that the content would subsist and required to be and the advocate is required to be and necessary inquiry is required to be completed for necessary inquiries to be conducted for fixing the responsibility of the persons for violation of the applicable law. While the said observations are made in paragraph 13, so they are in the nature of passing remarks, observation to be attended to by the authorities in accordance with law. They do not form part of the operative portion of the order. Therefore, when they do not fall within the operative part of the order, they cannot, the complaint about non-compliance, the non-compliance thereof cannot amount to contempt. The contempt proceeding is liable to be closed. It is accordingly dismissed as not survived.
Next.
number 98.
Lord, this writ appeal is filed selling the order of this single judge, honorable single judge, rejecting my writ petition, which was filed, permit me to vote in the forthcoming election. Lord, I am the government employee. I am the member of the third respondent association. I paid requisite fee and became the member of the association. Whereas the impugned list prepared, my lord, my name is not forthcoming. And the election by the third respondent is scheduled on 25th of this month, my lord. Therefore, I filed writ petition seeking the direction of this honorable court to include my name, which was rejected. My lord, there were several writ petitions were filed before this honorable court and in Kalburgi bench of this honorable court also. The honorable Kalburgi bench has allowed their petitioners to cast their vote as well as contest in the election. As far with order of this honorable court of Kalburgi bench, therefore interim order is also sought. My lord, I have produced copies of the honorable single bench of the Kalburgi bench at page number 69, annexure E1, E2, there are several writ petitions. This honorable court single bench has ordered to permit the petitioners therein to cast their vote subject to challenging the list before competent authority. My prayer in this petition is also, kindly permit me, admittedly I have paid fees, to cast vote on election held on 25th, and further list I will challenge in the appropriate authority. Kindly consider page number 69. 69. Annexure E1. Lord, this is the order passed by the honorable single judge in writ petition number 202836 of 2024. Last few lines, my lord. In the meanwhile, petitioner is permitted to cast his vote and his nomination and contest the elections of Karnataka State Government Employees Association, Bidar unit, scheduled to be conducted on 16/11/2024, subject to the condition that petitioner shall not vote and contest from the Koppal district. That different matter. Again, in writ petition number annexure E2 in next page, this is one more petition. Very honorable court allowed the petitioners. There are such several writ petitions were filed. So honorable Kalburgi bench has permitted to vote as well as contest. But in this petition, my lord, I am seeking for only voting because already nomination paper, receiving nomination paper and rejection return, everything over. My only prayer in this petition is to permit me to vote in the upcoming election on 25th. The honorable court in writ petition rejected my petition on the ground that, Lord, at page number 13, writ petition order, my lord. Page number 13, my lord, in the writ appeal, particularly para A's, small a, my lord. The election process of the managing committee of the society has already commenced as per established principles. Once the election process begins, the court should not interfere, as doing so could disrupt the election process. My lord, the settled position of law from the Ponnu Swami, M.S. Gill, and later the whole law was summarized in Election Commission of India versus Ashok Kumar in the year 2000. My lord. I produced Honorable Supreme Court judgment in Ashok Kumar, my lord. Please. Well, the question was whether there is absolute bar in entertaining any writ petition in the form of under 227, 226 and 27. Particularly para 32, my lord. The Honorable Supreme Court has held, yes, once election is para 32 sub para 2, my lord. Sub para 2, my lord. Page number 17, my lord. In page number 17. Para number 32, my lord. I read para number 32. For convenience sake, we would now generally sum up our conclusions by partly restating the what two constitution benches have already said, and then adding by clarifying what follows therefrom in view of the analysis made by us herein above. Para sub para 2 is relevant, my lord. Any decision sought and rendered will not amount to calling in question an election if it subserves the process of the election and facilitates the completion of the election. Anything done towards the completing or in furtherance of the election proceedings cannot be described as questioning the election. But in this petition also, I am not seeking staying or quashing the very election process already started. My only prayer is, since I paid subscription fee, I am entitled for voting in the upcoming election. Only prayer is to permit me to participate in the proceedings, in the election process. I'm not seeking for any stay or quashing of any order. My prayer is only restricted to that part.
Or learned advocate Mr. So-and-so for the appellant, this appeal under section 4 of the Karnataka High Court Act 1961 is directed against judgment and order dated 20th November of learned single judge, whereby the writ petition came to be dismissed. The prayer in the petition was to direct respondents 3 and 4, who are the Karnataka State Government Employees Association and the state returning officer, to add the name of the petitioners in the final list of voters. The elections to the state council members from Bengaluru Urban District was to be held, for which the notification was published on 13/9/2024. It is the case of the petitioner that when list of voters was published in the second week of November 2024, name of the petitioners were not included. Therefore, petitioners were aggrieved. While dismissing the petition, Law National Judge has rested his reasoning on the cogent ground that the election process for the managing committee of the society had already commenced. And once the election process has commenced, the courts would not interfere. Full stop. As the election process is underway, the relief to the petitioner cannot be granted, since it will amount to interjecting with the election process and upsetting the entire election schedule. Full stop. It is an admitted position that the election is to take place. Voting is,
Please, madam.
casting of vote is when?
on 25th of this month. 25th of this month.
It is an admitted position that the voting is to take place on 25th of November 2025. Full stop. Most of the stages in the election process is exhausted. Full stop. Paragraph. Therefore, in the above ground alone, comma, the court is not inclined to interpose itself in the midst of the election. Also, the reasoning adopted by learned single judge, eminently just, proper and legal. No cases made out by the appellant. The writ appeal is dismissed, paragraph. Writ appeal is dismissed in paragraph. The remedies for the petitioner would be available after the completion of the elections, for which this court does not express any opinion on this.
Fresh writ appeal, November 23. Raymond.
For the petitioner's counsel.
BBMP 23, we reached up to 23 on.
Lord, during COVID, Government of India, my lord, had issued a note, my lord, an order directing that, my lord, 100% of the wages, my lord, should be paid to the workman. That was assailed before the Honorable Supreme Court. Please come to, my lord, running page, my lord, 90. Honorable Supreme Court had, my lord, said no coercive action to be taken. Sorry, my lord, 134. Supreme Court order is 134. My apologies. 134 at 137. (137), my lord. In the meantime, no coercive action against the employer shall be taken pursuant to the notification. Then, my lord, sorry. Then, my lord, another order came to be passed at page 138. My lords may come to, my lord. The Supreme Court, my lord, directed that, my lord, there should be, my lord, discussion and all that. Please come to page 161, my lord, for a minute. 161. (15 lines from the, sorry. My lord, 15 lines from the top, my lord. The obligatory orders have been issued on 29/3/2020, that's, my lord, 100% wages, which have been withdrawn with effect from 18/5/2020. In between, there has been only 50 days during which period statutory obligation was imposed. Thus, the wages of workmen and employees which were required to be paid as per the order dated so and so, other consequential notification was during these 50 days. So, my lord, that 50 days, my lord, continues, though, my lord, prospectivity is withdrawn. Thereafter, my lord, the Honorable Supreme Court itself, my lord, the memo passed an order. Sorry. Just give him one copy.
I have in my mobile.
Okay. Page 2, my lord. After hearing the learned counsel of the parties, at present, we are not inclined to enter in the petition under Article 32 of the Constitution. Petitions are accordingly dismissed. However, all contents are left open to the parties, including interveners, to be raised before the appropriate forum. So, my lord, we filed a writ petition before this honorable court. Initially, my lord, an interim order was granted. Ultimately, my lord, an order came to be passed at page 36. Learned single judge holds that, my lord, the para 9 at page 52, my lord. Starts at 39, page 50, page 52, para 9. It's already been withdrawn. Therefore, my lord, no requirement to consider. And but then what has happened is
They have raised, my lord, now industrial dispute. That, my lord, reference is made, but this, my lord, issue, my lord, is not before the reference court. So, my lord, the order, my lord, states at us, unless your lordships are able to pay, my lord, page 52, my lord, 52, para 9, my lord. As regards the question of constitutional validity of the impugned communication dated so-and-so, order dated so-and-so is concerned, in view of the fact that the aforesaid communication and order have already been withdrawn on 18/5/2020, requirement of consideration of its constitutional validity would not arise. Relief sought is therefore rejected. My lord, page 161, Supreme Court itself says, my lord, that 50 days, my lord, it continues to be valid. Please come to 161. My lord, my difficulty is only this. (161), my lord sees, my lord, that is after that 18/5 was, my lord, the withdrawal of that. Obligatory orders have been issued on 29/3, which have been withdrawn with effect from 18/5/2020. In between, there has been only 50 days, during which period statutory obligation was imposed. Thus, the wages of workers and employees which were required to be paid as per order dated so-and-so and other consecutive notification was during these 50 days. So, my lord, the order continues, and, my lord, the Honorable Supreme Court directed us to, my lord, approach the appropriate forum. That is, my lord, we came before your lordships. My problem is, I go before, my lord, the industrial tribunal. Now, my lord, they have made a reference. That reference order, my lord, if your lordships come to, it is only, my lord, this issue, my lord, is not 120. This issue is not referred. My problem is only that. If my lords are saying, my lord, are willing to, my lord, hold, or, my lord, give a observe that, my lord, this notification does not come in the way of, my lord, the authorities considering it independently. My lord, I have no problem. Otherwise, no constitutional validity, my lord, they have no power to, my lord, examine. 120, my lord, is the order of reference.
Which notification?
That notification, my lord, of the government, my lord, 29/3, which at page 161, my lord, the Honorable Supreme Court held that, my lord, 50 days, my lord, it continues to exist.
Page number 90, my lords. Page number 90 in the appeal memorandum. That is the
Page number 90.
990. My lords.
Oh.
During pandemic period, the notification issued by the National Executive Committee under the Disaster Management Act. First notification, first order.
Para 3, my lord, at the bottom. That's the issue, my lord. All employees, be it in the industry or in shops and commercial establishments, shall make payment of wages of their workers at their workplace on the due date without any deduction for the period of the establishments under closure during the lockdown period. We did not work at all. We, my lord, did not have. In fact, if your lordships look at, my lord, the Payment of Wages Act, 7(2)(b).
Number 11.
7, my lord, 1. Sorry. Notwithstanding the provisions of the Railways Act, so and so, the wages of employed persons shall be paid without deductions of any kind except those authorized by or under this act. Now, please come to, my lord, 2, subsection 2. Deductions of the wage from the wages of an employed person shall be made only in accordance with the provisions of this act, may be made, maybe for the of the following kinds only, namely, B, deductions for absence from duty. Section 10, my lord, 9 indicates as to, my lord, what is the, how it has to be, my lord, deducted. Section 9, deductions may be made under clause B of subsection 2 of section 7 only on account of the absence of an employed person from the place or places where, by the terms of his employment, he is required to work. Such absence being for the whole or any part of the period during which he is so required to work. None of them, my lord, came for the work. My only problem is, my lord, there is a reference now to the industrial tribunal. The issue, my lord,
appellant, may I request a matter to be taken up Monday or Tuesday, my lord, some inconvenience.
This was actually moved because an interim order was obtained by concession given by the learned advocate appearing for the government. Though there is a matter is remanded, there is no locus standi for the other side, who is only a legal representative to file an appeal also.
We'll consider on 28.
28th, please, man.
As requested.
Obliged.
Number 25, 26 are urgent. So number 27, it's a commercial appeal. Mr. V.B. Shivkumar. Number 27,
January.
Manoj, I appear for the respondent of this matter.
Yes, nobody is there for appellant. It will go to January.
Very well.
January 9.
I'm grateful, Manoj.
28, 29 are urgent. Seal number 30,
I appear for
the
the.
complaints in contempt matter.
The state has filed a compliance affidavit in this petition, basis which my respectful submission is that nothing else survives in this contempt petition.
Nothing, sir.
Nothing else survives. They have
Done.
complied with the order now.
Learned advocate Miss
Anisha Atresh.
clearly stated that the order and contempt is complied with and nothing survives in present contempt petition. Learned additional government advocate Timothy Pramod indication confirms the statement of compliance in that view. As nothing survives, the contempt petition is disposed of accordingly.
Seal number 31 to Balaji Naidu.
For respondents
I
1,
made an-
2, and 5 in 31.1.
Interim application, my lord.
May I?
Interim application for an interim order, my lord, against respondent number 7 from putting up further construction. In spite of the confirmation order by the BBMP and the notice against them for having violated the and unauthorized construction, my lord, they are continuing to be construction. They are not responding to the BBMP order also. I had produced along with my IA also where the BBMP has confirmed the order
Second.
against respondent number 7. Kindly see the document number 9, my lord.
May I just submit this before we let it continue? The stand taken by respondent number 7, that is GAIL, Gas Authority of India, is that this is not a PIL, this is actually a private litigation. His brother, the petitioner's brother, has already filed a writ petition which is pending in this honorable court on this issue to which GAIL is not a party. He is now coming forward by way of a PIL. The petition numbers are also disclosed.
It is nothing to do with this PL is concerned.
Same
Let
line.
us where it is disclosed.
Well, in my objections, which we have filed on 5th April 2022, respondent number 7 objections. Writ petition number 22633 of 2021. yes. In 22633 of 21, 5th April 2022. Page 15, document number 3 is a legal notice issued.
In your statement of opposition dated
In my objections as said, so yes.
dated 5/4.
Yes, ma'am, filed on 5/4/2022.
Correct.
That's right.
So at which page?
Well, at page 3, para 10.
3, page 3, para 10.
Page 3, para 10, I referred to the legal notice issued by his brother. And I produced it at page 15. This is the legal notice, my lord, at page 15, para 1. Our client represents to us, page 16.
They have filed rejoinder.
At page 16, para 1, our clients represented to us that they are the class 1 heirs of one late so-and-so who was the owner of survey number 4/1 and 4/5 and survey number 7 of so-and-so village. And raising a claim, which is survey number 7 is the subject matter. Para number 7, in this legal notice, they refer to the fact that certain writ petitions are pending. Para number 7 at ink page 18. One of these writ petitions is filed by his brother. Para 7, my lord, page 18. Our clients further represents to us that for the fraudulent diversification of the land bearing number so-and-so, they both along with others constrained to approach Honorable High Court by way of filing writ proceedings, same to be registered at WP number 57624 and so-and-so. Both matter is pending consideration on interim prayer sought by our clients. These are challenging the acquisition of these lands. And at ink page 24, my lord, where the petition number 57624 is mentioned, I have produced the cause list, which shows that the petitioner's brother is petitioner number 7 there. At page 24, petitioner is petitioner number 7, in that petition is the petitioner standing before this court.
By record.
By record. It's the same petition.
Same petition.
Same petition. So he's already filed a writ petition questioning the acquisition of the land and use.
Very land. Very land.
Very land.
So here where will you find the description of the land in this petition?
I am not the party there.
In this petition, where is the description of the land?
My lord, in this petition, writ petition.
Survey number 5 and 6 or what?
Survey number 7, my lord, I pointed.
Survey 7.
7. Lord, at page 13,
Survey number 4/1 and 4/5.
well, prayer A in the petition to issue a writ of mandamus or any other writ order or direction directing the respondent numbers 1 to 3 to remove unauthorized constructing on road, park and open spaces formed in survey number 7.
But your notice doesn't refer to survey number 7.
It does. I
Let us-
pointed.
It is there, page 60.
Lord, at page 16, it specifically mentions survey number 7, para 2.
So writ petition challenging the acquisition
That's
of the same land
of the same,
by your brother,
by his brother.
his brother.
And he is also a petitioner. He himself is a petitioner in that writ petition and he now comes by way of a PI.
And what is this PI?
Well, Lord, in respect of this only, that seeking to prevent Gale from utilizing the land. I have taken permissions, I have got approvals, everything I have produced.
Who are you?
I am Gas Authority of India Limited.
Gail.
Yes, ma'am.
So it is required for you.
Land is required for me.
So only 2 questions now.
That may have filled the rejoinder also, my lord, where
No rejoinder is necessary. No
Lords,
rejoinder.
may I submit? In item 31.1, my lords, we have filed an IA depicting that they have not produced any document before the BBMP authorities. BBMP, in fact, has given notice, my lords. They have not given any, they have not provided any documents. Lords, that IA has to be put up before your lordship. Lords, there's some issue with my video. Kindly, my apologies, my lords. That IA has to be put up, my lords. IA number 2 of 2024 has to be put up before your lordship, so that we can show that the respondent number 7, that is Gail, has not obtained any permission. If they had obtained the permission, they would have submitted it to the respondent BBMP, my lords, which they have not done.
This person is in a different petition which came to be filed after Gale Gas filed its objection saying that this man is no longer holding a public interest litigation, it is private interest litigation. He is a third party. What is his interest in the land in this issue also is not to be seen.
We are the residents of Jalali village, my lords, wherein we are utilizing that road which has been illegally acquired by Gale, my lords now. wherein they are putting up unauthorized construction. There's a road, my lords, which has been encroached.
All that is a subject matter of that petition that is pending.
No, that is in so far
Lords,
as.
if our IA is taken up, my lords,
Unauthorized
the fact.
road construction, unauthorized construction in the road, which is formed part and parcel for the public purpose.
Even if there is a limited overlapping of the subject matter of this public interest petition with that private interest petition, will not entertain.
So that, I had filed the rejoinder also claiming that the survey number 7 is not part of that writ petition. We are not claiming against survey number 7.
What do you want? You are inviting order or inviting cost?
May I have it next week, my lord?
No, not possible. These are the petitions which waste the court of the time of the.
May I be permitted to make my submissions, my lord? I am appearing for this BBMP. Lord, respondents 1, 2, and 5. My difficulty now, my lord, is under this PIL. I am appearing in the second petition, my lord. A direction has been
The
sought at
second
the hands of this court. There are 2 petitions before your lordships.
2 petitions.
Yes. 31.1, I am representing.
So what is that same?
Same prayer. One
Same
second.
prayer is by a stranger, because
That is where.
they'll find this objection.
No, one
You
second.
are
Let me
tainted,
make
you are holding a private interest in a public interest litigation. They put up somebody else to come and file a second petition after I filed this objection.
No, they claim to be, my lord, in this petition, the petitioners, my lord, claim to be public, general public. They are having some interest. They say that there is a road which has been blocked by Gale authorities in the guise of putting up construction. Accordingly, my lord, a complaint is lodged with me, asking me to take action. My lord, based on this complaint, my lord, I initiate appropriate action against, my lord, the unauthorized construction. When I go for inspection, my lord, they say, my lord, when I go for inspection over there, I find some unauthorized constructions coming over there. My lord, then, my lord, immediately I initiate appropriate proceedings under 248, 1, 2, and 3. As on today, even 3 is also issued. That is confirmatory order as per the BBMP Act. My lord, despite, my lord, requesting them to stop the entire construction, my lord, they are not doing. My difficulty, my lord, is this now. Despite, my lord, me issuing confirmatory orders, now, my lord, HMT is filing complaints against me before the jurisdictional police, saying that I am unnecessarily interfering with the construction aspects and things like that. My lord, I may be permitted, my lord, to produce these documents along with the drawing which the Gale gave to me, my lord. My difficulty, my lord, is this now. I am unnecessarily, my lord, inviting these complaints based on this prayers, my lord, which they have asked. And it is my duty to go there, find out what exactly the situation, whether they are putting up construction in accordance with law and things like that. When I go for inspection, my lord, they do something like this.
So this land are under acquisition.
Please, my lord.
Land are under acquisition.
Yes, that's right. Lands have been notified, acquired, given to HMT. HMT has then given it to me on lease.
Already acquired.
Long
back, man.
Long, years ago.
Years ago.
Years.
No, thing is, what they say, my lord, is this. There is a road which is running insofar as that particular property is concerned. The road, my lord, they say that these people have closed it and then they are putting up construction. When I go there for inspection, this is what I incur. Kindly see the, I am producing these documents, my lord. I am permitted to see it.
Part and parcel which is running through 7 also, my lord, which has been obstructed by the Gale
Subject matter of this subject matter of this PIL is elsewhere being put, then we are not.
That's right.
So far as to first petition, my lord. Second petition, my lord, it is a general public.
You have taken action in respect to unauthorized construction.
Please, my lord.
You have taken some.
Yes, I have taken action. May I be permitted to pass on this, my lord? Satori.
They will do their job. Suffice.
Unfortunate scenario, my lord, is that on 11/11/2024, a complaint is lodged against me.
That suffice. In case if the BBMP takes further necessary
Right.
action, that survive my petition.
Provisional order is issued, show cause notice is issued, no reply, confirmatory order is passed.
We'll have only take note of the submission of, we'll only record the stand of the BBMP and dismiss both the petitions with cost which you will quantify.
I only request, my lord,
I only endeavor to see that the public road is being free free movement to the general public. It's not for me.
It doesn't appear to be bona fide.
my lord, my only request is, a protection, my lord, has to be given to me. I am not allowed to do my duty now. I go there,
Not by us.
try to stop the construction, and I face a complaint.
Both are dismissed.
Great.
Both are dismissed.
Let that BBMP take further action in that regard. They
We'll
already.
appropriately observed. He is saying we'll record that stand, that's all. In accordance with law, whatever they are doing.
My lord, I only say this much. My problem now, my lord, is that I am facing complaints at the hands of HMT, my lord. They are lodging complaints against me.
BBMP has nothing to.
If I go, that's exactly what is happening. 11/11/2000, as recently as 11/11, they have gone and filed a complaint against me, police complaint. That also is placed on record before your lordships. They're not allowing me to do my duty now.
Please let that observation be noted, my lord, so that the BBMP can take further action in that regard. Only to that extent, even my endeavor is only that the road to be free access to the general public, that's all.
We are simply dismissing both the petition, taking note of the stand of the BBM.
Yes.
The one
Highly
line
obliged.
announcement in both the petition.
Highly obliged.
So we'll give reasons, but just telling.
Obliged.
Please.
Number 32.
I appear for the respondent, my lords.
Defendant's commercial appeal, my lords. Defendant's commercial appeal. Notice was ordered, my lords. 15 lakh rupees I was supposed to deposit. By 25/9/2024, I deposited, my lords, 7.5 lakhs. 15 lakhs was to be deposited, my lords. I sought, my lords, interim protection and, my lords, some more time for depositing, compliance the direction of this honorable court. My lord, total decretal amount was 16,34,867. This honorable court, while issuing notice to the respondents, directed me to deposit 15 lakhs, my lords. Out of which I deposited 7.5 lakhs, my lords. I sought some more time, my lords, to deposit. They have filed execution petition before the commercial court, pending disposal of this appeal, my lords.
So you want extension of time
Yes, please,
to
my lords.
deposit.
Please.
Why you are not able to deposit?
It's a very small organization, my lords. We will deposit, my lords. We will obey the court order, my lords.
Lords, I appear for the respondent. I beg to differ with my learned friend. It is not a small organization.
But we'll
They have
grant-
substantial resources.
We extend further 4 weeks to deposit.
Lord, may I make a small request, my lords? A date may be fixed for final hearing of the matter. It's a very short appeal, very small points for consideration, lords.
The coordinate bench of this court by order dated 25/9/24. Passed in order, inter-alia, granting stay of the operation and execution of the judgment and decree impugned in the appeal on condition that the appellant applicants deposits total amount of 15 lakhs within 4 weeks. Today, when the appeal came up for consideration, learned advocate for the appellant applicant submitted that due to bona fide reasons, the applicants could submit only 7.5 lakhs and 7.5 lakhs requires to be remained. He pleaded that further time of 6 weeks may be granted, within which the applicant should deposit the remainder amount of rupees 7.5 lakhs. Since the court has granted interim stay and the appellant has deposited 50% the amount, the extension for depositing the balance amount would be considered favorably. Full stop. In that review, considering the submission of learned advocate for the appellant, 4 weeks time from today is granted, within which time the appellant shall deposit the balance amount of 7.5 lakhs, failing which the stay order shall automatically get vacated without order of the court. Full stop. The appeal shall be listed further. The appeal shall be next listed on 9th of January.
Interim order is extended.
Continues.
My lords, LCR may be called. LCR is called, but yet to be received, yet to receive my lord, from the trial court. TCR is called.
We are not doing anything except extending the.
Please.
The interim stay shall continue on the above condition.
Number 33.
On the above condition of depositing the balance amount within extended time.
Number 33. Nataraj Balla.
Lord, I have filed additional documents, my lord, along with the IA. Additional documents are filed, my lord, that is put up today. Challenge is to annexure J, my lord. Notice was not ordered to the respondent number 6, my lord. Objections were filed by the government, where they say a challenge, say that there is no locus standi for the petitioner to approach. I filed a rejoinder, my lord, where my application for impleading was not even considered. So I have a locus, my lord. The facts are, my lord, I have applied for a license of Quarry. Respondent number 6 might be a necessary party.
Lords, we have filed a statement of objections. As stated, we have questioned the locus standi of the appellant, my lords. Now they have filed certain documents which we have not received. We will take instructions on those documents, my lords. Basically, in the revision petition, the petitioner was not at all made a party. Not so.
20th January.
Obliged.
Number 34. K.N. Manjunath, party in person.
Yeah. Remember?
Item 34.
34. Recalling.
This recall petition we have filed for recall of the order dated 31/5/24 in the petition number 9903 of 24. The order is very, very bad in law and very, very bad in facts. Contradicting and going against the Interstate River Water Dispute Act 1956. And the respondents have misled this court repeatedly, recklessly. Still, we suffer from dismissal. And after getting the dismissal order, we have issued a notice for the respondents under Interstate River Water Dispute Act, Clause 6(3)(a). Sir. Please refer IA number 2.
What are you doing in life? Vide, what are you doing in life?
I am a retired agent BSNL. Retired.
You are retired.
Retired.
Now tirelessly filing public interest litigation.
Sir,
Tirelessly filing public interest litigation.
this is the only one I have filed so far.
Only.
Sir, we have issued, sir, Annexure A2, sir, page number 13 of IA2 for recall of this.
It is there. We have
Sir,
II.
Notice for suing under ISR Act 1950, Section 6(a)(3) for criminal dereliction of statutory duties and functions of CWMA jurisdiction. After getting your order, dismissal order, on that basis, we have issued a notice under the same Interstate River Water Dispute Act under 6(3)(a) with a copy to the Minister of Water Resources. So after going through our notice, he has taken a special clause to the respondents. How you can make such blatant lies statements before the Constitutional Court, High Court. The petition was dismissed mainly on 2 points. The Kaveri Tribunal is still functioning since decades. And this Honorable High Court has no jurisdiction to intervene in this matter. Only 2 points dismissed. Both are totally false in terms of law under Interstate River Water Dispute Act. Same act. I'm not going out of. Under the same act, this law is very, very bad in, this order is very, very bad in law and facts. And we have issued a notice for that. The minister has ordered the CWMA chairman to reply the notice promptly. For our notice, the CWMA chairman has replied. Annexure A3, page number 15. They very, very shocking statement they have made, sir. They have given a copy to me, I filed there. Sir, please, on page number 16, A3, same A3, page number 16, sir. Copy to, bottom, please refer bottom line, sir. Copy to Sri Shanti Bhushan H, Deputy Solicitor General of India, High Court of Karnataka, Bangalore. With a copy to him, with a copy to me.
Copy to Shanti Bhushan.
Shanti Bhushan, and he is not here. I want him, sir. I want his presence here.
You want him? We'll call him. How will call him?
Sir?
How will call him? In what way we can call him?
No, because the Shanti Bhushan, they have referred the matter to the Shanti Bhushan because he has made the false statement before this court, misleading court. He has made. That is why they have referred to him also. And if he is there, sir, matter will be free. You can decide within 10 minutes. I want him only, sir. Shanti Bhushan only. Otherwise, if she is answering, she has to answer my questions. Sir, I want to know whether she is having a copy of this Annexure A350 from respondents. That she is having the copy, I don't know.
You copy.
You are having? Then please read this. Please read the letter. It is their reply, sir. Let them read. I have to ask a lot of questions are there. Please read, madam.
She will not read because you say.
Oh, no. I'm requesting.
Please say she will read.
Okay, you please, director to read the letter.
Not supposed to conduct the court proceedings.
Sir?
You are not supposed to conduct the court proceedings.
No.
In a manner you want, you can't argue and
No,
instruct the counsel.
Sorry, sir. No, I am not with the.
Since we are not saying anything, it doesn't mean that you cross the limits of discipline of the court.
Sir?
Since we are not saying anything to you, that doesn't mean that you cross the
No,
limits.
sir. I am not. I am only asking her to read
Yes.
the letter, sir. Their own reply.
You go on speaking anything and anything like you like.
No, sir.
You call the Shanti Bhushan, read the affidavit. What is this? This is not the place of a public place where you can talk like this.
No, sir. That is where all the points of law and facts are highlighted, sir. That is why. Because what I am thinking, she may not be having the copy and she may not be knowing the matter. That is why.
It is not your business. You argue the matter.
Okay, sir. Then I will read the letter, sir. Sir, the Kaveri Water Regulation Committee, that is from their letterhead, I received the email on 9/8/2024. They are telling, sir, I am directed to say that the Central Government Council in cases WP 2428 of 23 and WP 9903 of 24 in the Honorable High Court of Karnataka, Bengaluru, has been intimated wide this office letter of even number so and so about the contention raised by you in the notice dated 1/8/2004, my notice. And further in the second para, they are making very significant observations. The Central Government Council in the above cases has been intimated why this office letter even number 882 that the CWMA has not submitted any written statement or has not filed any affidavit to the Honorable High Court through Central Government Council in the above court cases.
We'll continue.
Sir, it's second point. The CWMA has not submitted any document or written statement or briefing material to the Central Government Council in the above court cases. They are distancing themselves away from what is recorded in the orders.
We'll continue your submissions next on the next date.
Okay, sir, date Monday.
Get the date. No. The court master is the master of the date.
Okay. Okay.
Item 74. Item 74, I have complied with the office objection.
Pardon?
Item 74, Maharaj. Prepare for petitioner. I have complied with the office objection. There is some urgency. Because Maharaj, the house is being started. The pollution control has granted permission. Not in violation of the Air Act and Water.
Third.
Third of. Great.
Serial number 96. Serial number 96.
76.
96, Monday or Tuesday. Because the land acquisition, the authorities will have come to disposes from the land. There is a house, they are considering the house.
10th January.
That urgency.
Yes.
Serial number 61. I have filed an IA for amendment of cast title. Accused three's name is mentioned as wrongly mentioned instead of Rajiv Kumar it is mentioned. That amendment application.
Tomorrow, not tomorrow, Monday.
Serial number 16.
Monday.
58, your lordships. Serial number 52, your lordships. It was with regard to that matter which was supposed to be heard, your lordships. I had requested the matter to be heard because your lordships passed an order, interim order on day before yesterday with regard to Mandya, KRS Dam, your lordships, in 1935. The writ petition, your lordships passed an interim order saying that it should be considered by the Dam Safety Committee. So these are all similar placed matters. In the sense, if the Form C license is not granted to me, my application before there will get rejected. This is, I've sought only a writ in the nature of mandamus, because the license is already expired now. If the matter goes before the Dam Safety Committee, if now my application for mandamus is not considered, I'll not be.
26.
Yes. Much.
Serial number 69. FIR has been registered against me in Haryana along with my super senior citizen parents. Tomorrow shorter date is required for urgent hearing.
Date will be given by court master.
May I request for 230 on
kindly listed.
Whatever date you.
May I request
66 and
29.
On 26, may I request for 230, Your Lordships?
Well, 66 and 67, I sought for the deletion of the A2, my lord. And also I sought for the release of the amount, my lord. The KDB acquired the land for some urgency is there, my lord. The applicant beneficiary is a bedridden, my lord.
January 11.
Bedridden, short date, me.
Court is not possible.
My lord, my serial number is 51. It is not called.
51.
Actually, I am going on vacation from December 7th to January 20th. So if you can post it before or after, I'll be okay. And it is just an impleading application, my lord.
What is the
It is
matter?
an application. The respondent has filed writ petition and I wanted to implead in that case.
51.
Yes.
Who appears for the petitioner? Anybody is there?
Including application which was dismissed, my lord.
So party in person is not there. It will go. Sorry,
Okay.
you are the party in person. You will keep it in January.
January 20th till 20th, I'm not there. December 7th to January 20th.
Take your date. Whatever date you want.
Date, 20, after 20th, any date.
You after 20.
It is a very small submission. If I are permitted, I can tell now.
96 there is urgency.
Take the date, give the date, particular date. 23rd.
Serial 96, there is urgency in the matter. 96, my lord. Officials, land is acquired. There is officials, they come to near the spot, trying to dispose this from the 10 guntas of land, house is constructed. They are KDB.
This is you are only showing the Maruti car and what is Hero bike. What do we understand of this?
They have come near the spot, to the
But
land.
this is the urgency.
Now they are trying to dispose this from the land.
When we can keep it on 4th of December.
4th December.
Some confusion is there.
Serial number 49, review petition kindly. Serial number 49, review petition, urgency in this matter. Already answer was referred to the government advocate. Kindly take out notes to the government advocate. Respond number 2.
After
Kindly any date start.
Date will be given.